Members are attending in person in the room and remotely using Zoom, although I don't think they are. I'd like to confirm that sound tests were made successfully. Before we continue, I'd ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and to protect the health and safety of all participants, including and especially the interpreters. You will also note a QR code on the card which links to a short awareness video. I'd like to make a few comments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Is anybody on Zoom?
No.
Okay, I'll skip that part. Okay.
Except the
Okay, so for those on Zoom, at the bottom of your screen, you can select the appropriate channel or interpretation, either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, Mr. Baber, do you mind? For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can. We appreciate your patience and understanding. I want to welcome our witnesses back again for joining us today from the Department of Justice. Kristen Ali, Manager, Senior Counsel, Criminal Law Policy Section. Joanna Wells, Senior Counsel, Criminal Law Policy Section. And Marianne Breeze, Counsel, Criminal Law Policy Section. Now, before we get started, we are at Clause 4 debating BQ2 amendment, which is where we left off at the last meeting when it was adjourned. Also, I remind you that new Clause 1.1 and Clause 2 were also stood down for the benefit of all members. Once again, if you have sub-amendments or new amendments, please provide them in writing and in both official languages to the clerk. Now we're going to move to continue BQ2 at Clause 4. Sorry?
I don't believe we're in the right. I believe we're at Lib 1. That's all
Are we, okay.
To remove the word swastika. No, we didn't. We deliberately went to all of the offenses that related to the Attorney General, and we're supposed to come back. We passed Ms. Idlat's amendment, which is NDP 1,
Right.
and then we rejected it exactly, and then we went through we agreed by committee to go through all the ones that were related to the Attorney General. And then we should be back at Lib 1, which relates to the swastika.
Right.
Lib 1 follows Block 2.
Okay, on my thing it didn't. Does it? Okay.
It follows it.
Okay, sorry. Then apologize.
Okay, we're all good? Okay, thank you. Just a reminder, there's votes tonight. Bells are expected around 5:15, give or take. We'll deal with that when we get to it. That's for me. Okay, all right. Okay, all right. So we are ready to resume then. So we are on Mr. Brock. We're on, just to be clear.
We're on Block 2.
We're on Block 2, yeah.
Yeah.
Okay. Now, just before we move on to Block 2, and I'll get back to Mr. Brock, if BQ2 is adopted, Lib 1, CPC 6 and CPC 7 cannot be moved due to a line conflict. Okay, now we're ready to roll. Did you have your hand up, Mr.
Yes, I did.
Okay.
Thank you, Chair. And I have several comments to make, but
Here we
I'll
go.
summarize as best I can. It's clear that Bill C-9, and given the deal that has been worked out between the Liberals and the Bloc, has become a lightning rod to religious organizations right across this country. I have been inundated, as several of my colleagues at this table and several colleagues in my caucus, with concerned members of religious leaders of all kinds of denominations, that this is a direct attack on the freedom of expression and the freedom of religion. Given how toxic and how divisive this Bloc amendment is and will continue to be, and now with Liberal support, we are at an impasse. It's no small wonder that an additional 6 hours of resources have been devoted to this meeting. I also want to clarify a sense that the Conservatives have been deliberately blocking and filibustering any attempt on the government to prioritize and to move to study Bill C-14. That is an absolute lie. It has been circulated for at least 2 weeks now in and outside the House of Commons. One can only take a look at the dysfunction of this particular committee. The former chair of this committee had abruptly ended meetings, did not call meetings. I know our current chair also did the same last week. If that is not a deliberate stalling tactic on behalf of the Liberal government, I don't know what is. But it is clear that it is always and will always continue to be the priority of the Conservative Party of Canada to address the elephant in the room, and that is the explosion of violent crime in this country. Since my election in 2021, I have been singularly focused on strengthening provisions in the criminal code as it relates to bail and sentencing. I wasn't alone in this crusade. We've heard from premiers, we've heard from law enforcement, we've heard from victim advocacy groups, we've heard from municipal leaders, all advocating, pleading, and begging for this government to take real action. And what did the government give us? They gave us a failed Bill C-48, which did nothing to stem the tide. We had an election. One of the issues in the election was community safety. We all heard that knocking on doors. So it was a real surprise to me and to members.
Mr. Housefather?
Mr. Chair, is this relevant to clause by clause?
Yes, it is.
I'm not
I'm
sure.
getting to it.
I'll give Mr. Brock some latitude. I mean, he's been talking in anticipation of what may or may not happen in the
Yes.
future, but we're not quite there yet. So if you're addressing this clause, then Mr. Brock, you can continue.
So we had an election. A number of issues were front and center. Community safety and a government response to address community safety was front and center. We all anticipated that when we returned to the House in the spring, one of the first hallmarks of this Carney government would be the introduction of bail legislation to deal with community safety. That didn't happen. All through the summer, I anticipated that some proposal, some policy would be introduced that we would study in the fall. That didn't happen. Ultimately, C-14 was introduced. We studied it. We looked at it in the House. We debated it in the House. It passed second reading. It is now waiting in the wings to be studied here. So I want to make it abundantly clear to everyone who is watching this particular proceeding and to all of the groups who have an interest in community safety. I've always said and always will say that community safety is not a partisan issue. Regardless of your political ideology, everyone wants to live in a safe community. So given the impasse that we are at with respect to C-9 and the block proposed amendment, I have a proposal. And that proposal is to seek unanimous consent from every member at this committee. I'll read out the consent motion that I wish to adopt. That to improve public safety in our communities and to protect Canadians from repeat and violent offenders, the committee A, immediately prioritize the consideration of Bill C-14, the Bail and Sentencing Reform Act, and work together to report the bill to the House at the earliest opportunity. To B, sit through the winter adjournment to undertake meaningful consultations with victims, community leaders, police services and associations, and other relevant witnesses. And C, pause consideration of Bill C-9 to make room on the agenda for Bill C-14. With every day that we do not, as a Justice Committee, deal with Bill C-14, more murders are going to happen in our community, more sexual assaults, more extortions, more car theft. Victims are coming through loud and clear. They want this committee.
Mr. Brock, sorry, I have a point of order. Mr. Chang.
How is this relevant to the consideration of clause by clause of C9?
He's
Thank
moving
you.
a motion.
It's not relevant at all, in fact. We're in the middle of clause by clause, Mr. Brock. I understand your point. The one point I take from your comments is that you want to move forward expeditiously, which I think we can all agree with.
I do, and I'm asking for unanimous consent,
so
Chair.
But I don't think it's on point. We're dealing with clause by clause. Mr. Chang's
it
point of
doesn't
order
matter.
is accurate, and I agree with him. So we're going to move on to clause by clause.
Challenge.
So I'll give off, okay, that's your right. But just let me finish. I'm going to then give the floor to Mr. Fortin to continue discussion on that. So, but that's my ruling.
But
He's allowed to move a motion
you guys
during
can just
clause
give
by
consent.
clause.
Okay, Mr.
you not want to do
this
C-14?
isn't a debate, Mr. Lawton. There's been, hold on.
They don't
gentlemen.
care about the communities that are hurt by C-9.
Gentlemen,
right? Like,
please, all members on both sides, please speak when I give you the floor and not otherwise. Mr. Housefather, Mr. Lawton, applies to everybody. I would ask that you respect each other, respect the interpreters, don't talk over each other. I will give everybody an opportunity to speak when it's appropriate, but do not speak at the same time or when it's not your turn. I've made my ruling on Mr. Chang's point of order. Mr. Brock, you're challenging my ruling, is
Correct.
it? Okay. Mr. Clerk?
Thank you, Mr. Chair. Yes, thank you, Mr. Chair. So on the question, shall the chair's decision be sustained? We will go to a vote. Madame Lattanzio?
I want to sustain the judgment.
Yes, in favor would
In
be
favor to
sustaining
sustain it,
the
yes.
decision. I'm sorry.
Yes.
Yep.
Okay.
Thank you. Monsieur Housefather?
Yes.
Madame Dillon? Mr. Chang? Mr. Brock?
No.
Mr. Baber?
No.
Mr. Lawton?
No.
Mr. Gill?
No.
Monsieur Fortin? Oui.
So clearly the
thank you.
Liberals do not
Mr.
want
Brock,
to prioritize
Mr. Brock,
C-14.
you do not have the floor, Mr. Brock. If you will respect the chair and respect other members of the committee, when it's appropriate for you to speak and others, I will give you the floor. I would ask that you don't do it otherwise. Mr. Fortin, we are on your amendment BQ2.
Point of order, Mr. Chair.
Mr. Jenis?
Could you just clarify what the ruling was? Is it that a member can't bring forward a request for unanimous consent motion?
My ruling was that it was not relevant to the amendment we were discussing.
Is your ruling that relevance is required for a request for
Mr. Jenis,
unanimous
we went through this
consent?
the last meeting. The ruling was made.
No,
it
I'm
was
just asking what it
challenged,
was.
and it was upheld. So, Mr. Fortin,
I'm just
you have
asking
the
what it
floor.
was, Chair.
Well, and I've answered the question twice now. Mr. Fortin, the floor is yours.
Merci, Monsieur le Président. Alors, on est rendu à BQ2, si
Oh,
je
we're not
ne
on
m'abuse.
English?
C'est ça?
Sorry, let me change it to English.
Président.
2, if I'm not mistaken. So BQ2 in C9 would replace at 4.2 where it says, where there is an offense, hate crime against identifiable group, displaying one of the following symbols. And we would replace this by one single symbol. Say a symbol that is used principally in the sense of the bill. This means that the offense would have to do with an identifiable symbol of a terrorist group and no longer swastika or some similar symbol. The reason for this is that the swastika is a symbol that was used not only for the grave crimes committed during the Second World War by the Nazis, but it is also a symbol used by certain religious communities. And we don't think that they should be ostracized or indirectly punished. And paragraph C says that the two could be confused. This seems rather vague and counterproductive. So what we propose is that we would forbid those symbols that can be identified with a terrorist entity registered in the criminal code or listed in the criminal code.
Then,
I really hope they give it back to Brock and he just spends 3 hours talking about this. Her mic's not on. Your mic's not on. Hold on. Why are we not hearing anything? Let's go back to floor video. I think they're having issues with the translation.
so if you have comments on this amendment put forward by Mr. Fortin, the floor is yours.
Point of order.
Mr. Lawton.
I'm hoping you could please, Chair, cite the authority on which you determine it's out of order, because it sounds an awful lot like you're trying to prevent bail study from taking place. Yeah.
We'll talk to me at the same time, but I'll let you start over. Go ahead. Sorry. Okay. All right, Mr. Lawton, sorry I interrupted you.
I was just hoping you could cite, it sounds like you're just trying to predetermine the outcome because the Liberals do not want to allow study of their own bail bill. So I'm just curious on what authority you're saying this motion is not permissible when we're saying we can and should move to a bill on which there is a lot more consensus than there is on C-9.
Okay, that sounds like debate on a dilatory motion to me, but no, I don't, the editorializing isn't necessary. I understood what Mr. Brock was trying to do. I ruled that his motion was out of order because of the timing it was put on the floor, because we're in the midst of debating BQ2.
Point of order, Chair.
Mr. Jenis?
Yeah, Chair. I mean, very respectfully, the Green Book clearly identifies a series of dilatory motions, and I know you're in your second meeting in this role as Justice Committee Chair. It's page 1167 of Procedure and Practice, where the dilatory motions are listed. A motion to proceed to another item, you would only use that in a situation where you wanted to proceed to a different item from the one that was currently on the table.
If somebody wants to challenge my ruling, they're free to do so. We're not.
Could I invite
I'm not entertaining debate on the ruling I've already made.
Chair, I promise you I'm not making things up.
I've already made the ruling.
It's
if somebody wants to challenge my ruling, that is the right to do so.
In Procedure and Practice.
This is not a debate.
Could the clerk clarify the rules at least?
No, the ruling's already been made, Mr. Jenis. I've set out the process we're going to follow here.
Okay, what?
Okay, thank you. All right.
You don't get to make things up, though, Chair. There's a book.
Okay, and you don't get to speak when you don't have the floor. So, Mr.
Okay,
Jenis,
I have a point of order, Chair.
Okay.
I have a point of order.
Okay, now Mr. Brock is going to challenge my ruling. That's fine. Okay, Mr. Brock.
Okay. So on, sorry. Okay, so on the chair's decision, the question is, shall the chair's ruling be sustained? Sustaining the decision will be voting in favor. So, Madame Latenzio?
In favor?
Monsieur Osfather?
Yes.
Madame Dillon?
Oui, monsieur.
Come on,
Mr.
Block.
Chang?
Yes.
Mr. Brock?
No.
Mr. Baber?
No.
Mr. Lawton?
No.
Mr. Gill?
No.
Mr. Fortin?
Oui.
Come on, Block.
It's fine.
Okay, thank you. Is there any further debate on Mr. Fortin's proposed amendment? Ms. Latenzio?
Thank you, Mr. Chair. So with regards to the BQ amendment, which replaces the offense, so it only covers symbol used by the listed terrorist entities under Section 83.11, removing Nazi symbols. SS bolts and other hate symbols from the bill. The amendment removes almost all of the hate symbols that communicate hate, and asked, we've been asked, communities have come forward and they've asked us to address, including the Nazi symbols that we heard through the testimonies and other imaginary used images to intimidate people in public places. So groups have told us here in committee quite clearly that the problem they are facing is the open display of hateful symbols like the SS bolts, and narrowing the offense, that this would ignore what they've asked for, the specific amendment. So limiting the offense to listed terrorist entities would leave many of the symbols that the Jewish, Muslim, Black, LGBTQ plus communities and others have told us that are being used to threaten and harass them, really going against the spirit of this bill. So the terrorist entity list is small and slow to update. So this approach would make the offense far less useful and far less responsive to what is actually happening on the ground and in our streets. So we want this law to be practical for police and meaningful for communities affected, and thus this amendment would weaken it to the point where it no longer meets that goal. And so for that reason, we will be voting against.
Thank you, Mr. Latanzio. Mr. Lawton? Mr. Lawton, Mr. Brock, and Mr. Babber.
So I've cited an instance from a couple of months ago in my riding that is very germane to this a few times on this committee, which was that someone under existing criminal laws was arrested and charged for having a swastika mowed into their lawn. And there were no separate offenses in the criminal code, no additional police powers that were required for that. And this is an issue that, again, was another one of many crime stories that emerged in my riding. And I've had a great many conversations with police chiefs, with frontline police officers. And when they talk about what they want, not one of them has said they want C-9. They talk about wanting bail reform. They talk about wanting legislation like we've put forward in the Jail Not Bail Act, legislation that we have tried to, in this very committee meeting, move our attention to because there is a lot more consensus on it. And I find it shocking that the Liberals will get up in the House of Commons, accuse us of blocking bail work while denying the opportunity to get to it, Mr. Chair, and you're silencing me again.
I'll give you the floor back. We have a point of order. Ms. Latanzio?
Mr. Chair, again, there's a question of relevancy here today, and I think it's quite clear the Conservatives do not want to proceed with C-9. At every opportunity, we are invoking other pieces of legislation, which I am hopeful we'll be able to get to if we can finish with this one here before us. So we are very much looking forward to deal with other pieces of legislation that will come, that are before this committee and that will be forthcoming in this committee. But today, we should be, concluding our works on C-9. And it is very clear by the interventions, Mr. Chair, at every turn, we are trying to, stretch the time and not have to deal with this clause-by-clause study. And it's very apparent, and it's, and I would invite the Conservative members on this committee to move ahead so that we can move to the study of other pieces of legislation. You keep this up, we'll never get to it.
Okay, back to you, Mr. Law. I think it goes without saying, the sooner we get through this bill, the sooner we can get to the next bill.
Yeah,
I don't think we need to repeat that over and over again, Mr. Lawton. My point, and where it is germane, is it is about community priorities, it is about justice priorities, and I find it fascinating that the Liberal government is holding its own bail bill hostage and using that as leverage to force us to advance very bad legislation that will attack the rights of Canadians. I'm sure he does.
Mr. Chair, relevance to Block 2. This has nothing to do with Block 2.
I'm inclined to agree with you, Mr. Housefather. I mean, we've gone...
I cede the floor.
Thank you. Okay, Mr. Brock, I believe.
I see what the Liberal members are doing, Mr. Chair. They say one thing to the community at large. They say one thing to the House, and accusing us, including the parliamentary secretary herself, accusing Conservatives of deliberately blocking the study of C-14. I have now brought forth a unanimous consent motion that could have dealt with prioritizing bail and sentencing. To my colleague, Mr. Lawton's point, I'm not done yet.
I know, Mr. Brock, with all due respect, and I really don't want to interrupt anybody. I don't want
Well,
to.
then why are you interrupting me, Chair? I'm not even done my point. No one has raised a point of order. You're supposed to be independent, Chair.
I am independent, Mr. Brock.
Now when you interrupt me, you're not.
And if you're going to continue making the same point you did on the point of order
How do you know? Because you're not allowing me to finish my
comments. Because you just repeated the same thing.
You're not allowing me to finish my comments, Chair.
You just repeated
That's
the same thing.
completely inappropriate.
What I'm saying is you need to stick to the amendment we're dealing with right now.
And I'm speaking to that. If you'll let me finish,
okay,
I will speak to it.
As long as you keep it relevant to the clause we're debating, that'll be fine. Thank you, Mr. Brock. Continue.
Now, Mr. Lawton raised serious concerns about Bill C-9. Now, when we raise concerns about Bill C-9, that is extremely relevant to every clause by clause that we are about to consider. Because he is not narrowing his commentary with respect to Block 2 does not, by definition, automatically mean that he's not speaking with relevancy to the whole purpose behind C-9. That's where I object. That's where I wanted to support my colleague. That's why I wanted to call out these Liberal members who refuse to be honest with Canadians that we need to deal.
No, and I'm going to make this point whether it's a Liberal or Conservative or a Bloc member. If people are going to start calling each other names and using words like lying, this meeting is going to be really long, and I'm not going to put up with this. Well, Mr. Brock,
I'll sit all night, Chair.
And we might be.
Give me the resources, I'll sit all night.
I know better than that, and my colleagues on my right know better than that. Please, I'm just asking for a level of civility here. Do not use words like lying, ascribing sort of motive to people when they haven't been. It's out of line. So, Mr. Brock, you have the floor, but I'm pleading with you.
Well, and I hope,
sir,
Chair,
I will follow the same rules regardless of who is talking.
Sure, and I take your comments at heart, and I hope that when you hear your colleagues, particularly the parliamentary secretary in the House, using that type of language, that you will pull her aside and you will call her out. Okay?
Except
now,
we're not in the House. I can only control the process at the committee.
Right.
So let's
and
move
I
on.
wanted to continue, sir, because I had some grave concerns, and that's why I challenged your decision, because I don't know what authority in the Green Book that you are relying upon to rule that my motion that I just indicated that I wanted to deal with, which was a dilatory motion, was not appropriate to be dealt with here and now. You made that ruling saying the motion, the block motion, takes priority over my motion, and I wanted to ask you, perhaps in consultation with the clerks, what particular authority you are relying upon.
Okay, the issue's been dealt with, Mr. Brock. If that's the end of your submission, we can move on to Mr. Baber.
I'd quickly say, with respect to Block 2, that I'm mindful of the concern that Mr. Fontaine has articulated. However, that could easily be dealt with by an amendment that would remove the reference to the word swastika, as has been asked by various representatives of the Hindu community. However, I'd like to understand from the chair, and granted I am new here, nonetheless, this goes beyond our desire to talk about bail. I just want to understand the process here, and that is that if a motion is sought, every member it's I would almost think it's not just a matter of order, it's a matter of privilege that a member of this committee is able to ask for unanimous consent at any point. That would be a dilatory motion. But we have a situation here where the chair ruled, in my view, respectfully, incorrectly, and then is able to sustain his own incorrect ruling with a vote. So effectively what is happening here is you can dispose of decorum, you can dispose of the rules if the Liberal members vote in favor of doing such. And in that case, what's the point of having any rules? And so I'm asking the chair, please, to allow Mr. Brock to move his motion, and let's have a vote. Let's deal with C-14, with bail and sentencing. Let's deal with that right now. But to vote to effectively to suspend the rules, to continue with this terrible piece of legislation, C-9, is not appropriate.
Okay. My
Maybe-
ruling, to be clear, was that it was an inappropriate time to make that motion. If you or Mr. Brock or others want to make a motion at an appropriate time, that's different. But we have already moved on from that issue. So if you have other submissions on this amendment, the floor is yours. If not, we can move on to Mr. Gill.
Could you please clarify to me what is
No, I
appropriate
am
time
not-
and
I
what is
am-
not appropriate time?
Well, okay.
He can move a motion
Your
at
friend-
any time.
Your colleague back there has the green book. Mr. Gill?
Thank you, Chair. Thank you. And I would like to talk about what I am hearing in the riding where I represent. And every single person I'm speaking to is talking about that we should be looking after C-14 first because bail and sentencing is very important for all of us. And we all agree to a point that this is the legislation we have to put forward. And now we are delaying. And every single day we are delaying is causing problems in the neighborhoods, on the streets.
Point of order.
Mr. Chang?
How is this relevant to the clause by clause of C9?
It's not.
It is relevant, sir.
Well,
Chair,
no,
it
because
is relevant.
you're talking about a different piece of legislation. I'm imploring you, if you want to talk about C-9, which is what we're here debating, please do so. I'll give you all the time you want. We have unlimited resources as far as I'm concerned.
I'm coming to it.
Okay, but you haven't addressed it yet.
If you will keep injecting me
in the
for
circumstances,
these kind of
Mr.
point of orders, then I would not be able to
Mr.
speak.
Chang's point of order, I've deemed appropriate. I'm going to give you the floor back. If you want to talk about this bill and this amendment, please do so.
Yeah, and it is important for us to understand what we are hearing at the ground level reality, and then we have to work accordingly. Our main purpose is to look after what people are in need at this point of time, whether it's C-9 or C-14. And you know, and we all know, in fact, that extortion calls are coming every single time. You know, gun shootings are happening every single day. People are scared. You know, families are being targeted. Businesses are threatened. These are the things that we have to look after. And I would suggest strongly that we should be looking after C-14 right now, and we have to support the motion presented by my colleague, Mr. Brock, and we have to move
Point of
forward
order.
on that one.
Relevance again.
Mr. Chang?
Relevance.
I agree. Mr. Gill, you're still not talking about this bill or, more specifically, this amendment.
Mr. Chair, if that is the case, then I'll cede my time and then move on. But actually, you know, we should not be stopping anyone to speak when we are talking about the important legislation that need to be discussed at this committee meeting.
Thank you, Mr. Gill. Okay, any other further submissions on Mr. Fortin's proposed amendment? No? Okay, so before we put it to a vote, let me just remind you what I said at the outset. If BQ2 is adopted, Lib 1, CPC 6, and CPC 7 cannot be moved due to a line conflict. Okay, so we'll put it to a vote now.
Yes. On amendment BQ2, I will go with Madame Latenzio,
No.
Monsieur Osfather,
No.
Madame Dillon, Monsieur Chang,
No.
Mr. Brock,
No.
Mr. Lawton,
No.
Mr. Baber,
No.
Mr. Gill,
No.
Monsieur Fortin,
Oui.
defeated 1-9.
All right, amendment defeated. Thank you. Okay, so now moving on to
Lib 1.
Lib 1. So I will give the floor to Mr. Housefather.
Chair, this is a simple amendment. The Hindu communities and some other communities, the Jain community, view the swastika as a holy symbol in their culture. We can refer to the Nazi Hakenkreuz, which is the symbol that used by the Nazis without using the word swastika in the English version of the bill. And so my amendment, all it does is remove the word swastika from the English version of the bill. And I hope that this is something that we can all agree on, given the community's representations. Thank you, Mr. Chair.
Thank you, Mr. Housefather. Any other submissions on that? No? Okay, so we'll move on to vote on Lib Amendment 1.
On the vote.
On the vote.
Madame Latenzio,
In favor?
Monsieur Hausfather,
In favor?
Madame Dillon,
Oui.
Monsieur Chang,
Yes.
Mr. Brock,
Yes.
Mr. Baber,
Yes.
Mr. Lawton,
Yeah, yes.
Mr. Gill,
Yes.
Mr. Fortin. Unanimous.
Carried.
Unanimous.
Okay, amendment carried, which takes us to CPC 6, which I believe is Mr. Brock.
And MPs
Hold on, yeah, hold on.
there is a no.
Mr. Lawton.
Yeah, hold on. Oh, yeah. Sorry, just before you get the floor, Mr. Brock. If CPC 6 is adopted, CPC 7 cannot be moved to a line conflict. Mr. Brock, do you want to speak to this?
Actually, it's Mr. Lawton's motion
Sorry, Mr. Lawton.
amendment.
Thank you. So we have raised in the course of our study of C-9, study that has been sadly shortchanged because of Liberal obstruction, that there are grave concerns with a number of sections of this bill, how it will affect civil liberties, how it will affect, in some cases, the very communities that the Liberal government claims it will protect. And there have been several concerns raised specifically about the section on hate symbols. And we will be discussing those more thoroughly when we get to the clause at hand. But if we are to, as a committee and as a parliament, enumerate hate symbols, symbols that have vile meaning, symbols that carry a death toll that often bring up a lot of trauma to various communities, we need to be thorough with it. So I am proposing the following amendment, that Bill C-9 in Clause 4 be amended by adding after line 3 on page 2 the following: B.1, the communist symbol known as the hammer and sickle, or B, by replacing line 5 on page 2 with the following, scribed in paragraph A, B, or B.1, that it is likely to be. So in layman's terms, this is adding the hammer and sickle, the communist insignia, to the list of hate symbols. Communism has a death toll of 100 million people around the world. People have died as a result of dangerous and harmful ideology perpetrated by that. I've had a number of concerns raised by people who have lived under communist rule in Cuba, in Eastern Europe, people who see this as being an incredible evil that needs to be stamped out. The Soviet Union under Joseph Stalin from the 20s to the 50s saw some of the worst mass repression in history and mass killings, from the Great Purge to Gulag forced labor camps, collectivization and terror famine, a death toll in the Soviet Union of up to 27 million. You have in China under Mao Zedong, the Communist Party carrying out massive repression, causing the deaths of tens of millions through executions and labor camps and man-made famines. You have Cambodia under the Khmer Rouge from 75 to 79. One of the worst episodes of mass killing in the history of the 20th century, with up to 2 million people killed, including, that's around 25% of Cambodia's population. So if we are to describe what hate symbols are in law, we need to acknowledge the death toll of the hammer and sickle. So I move this amendment for consideration, that it be added to the list. Thank you.
Thank you, Mr. Lawton. Anybody else? Mr. Barber?
I have to give it to my friend, Mr. Lawton, really. As some committee members have heard by now, I was born in the Soviet Union, and I lived in the Soviet Union until 1989. And frankly, when I look at the hammer and sickle, I'm scared. I appreciate Mr. Hausfather's previous amendment, and I appreciate his sentiment, as we both come from the same community, with family who was deeply affected by the Holocaust. But I can tell you that my family has also been significantly affected by communism. And I frankly do not see much of a distinction between the two. The hammer and sickle represented collective oppression. If I could maybe summon my thoughts here, this is definitely interesting. I'm not sure if Mr. Lawton mentioned that it is estimated that subsequent to the World War, more than 20 million Soviet citizens who were murdered by the communist regime. And it wasn't just confined to Jews, it was everyday people, Ukrainians, intelligentsia, anyone who had any type of microphone, press members, educators. And so I view it as a hate symbol, and I believe that it is a hate symbol because it drives the extreme of collectivist ideology, where the state says, not my way or the highway, but my way or murder. And I hope that all my friends from around the table will support this amendment. Thank you.
Thank you, Mr. Weber. Any other discussion on that point? No? Okay.
We're going to vote?
Yeah, there's no more? No, we're going to vote. Okay, so we're on
CPC.
okay, Sal CPC carry. CPC 6 carry, sorry.
Okay. On the vote? Yes, so Madame Latenzio? Mr. Housefather?
Against.
Madame Delin? Mr. Chang?
Against.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Lawton?
Yes.
Mr. Gill?
Yes.
Mr. Fortin?
No.
Defeated 5-4.
Okay, so
CPC 7.
CPC 7, which is Mr. Brock this time, I believe, yeah.
Oh,
Yeah, CPC 7.
okay, thank you, Chair. Yeah, so the majority, if not all of us at this committee are lawyers. We can all think back to first-year law when we took statutory interpretation, and the overriding rationale that I remember so long ago, several decades ago, was to always seek clarity when drafting laws. And it's no more important when it comes to the Criminal Code of Canada. In my view, after some almost 2 decades of prosecuting and about 14 years of defending, as the criminal code currently exists, there are so many areas that really require significant editing. So what I bring to the table as a parliamentarian now is the ability to ensure that there are no gray areas when it comes to statute interpretation, that we strive and we look at the criminal code in terms of what's black and what's white. And what is existing right now in C-9, specifically subparagraph 2.2 sub C, as worded, a symbol that so nearly resembles a symbol described in paragraphs A and B that is likely to be confused with that symbol. I don't know what that means. It is so vague. There is no definition section as to what a like symbol would mean. What does likely to be confused with mean? Would that be an objective standard? Would that be a subjective standard? So in terms of the rationale for the amendment that I seek, it's to seek precision, to seek clarity, and to remove that type of language goes a long way. Thank you, Chair. That's my explanation.
Thank you, Mr. Brock. More than anything, you just reminded me how old I am. Mr. Baber, over to you.
I actually remember being taught over breath. It was by a former cabinet Liberal minister, Mr. Bentley, taught me first-year criminal law, and he made the criminal law come to life, for me at least. Of course, as the chair knows, I did not become a criminal attorney, but nonetheless, I appreciate Mr. Brock's input here. So if I just look at the section, and if we could please read it, and if I could please ask my Liberal colleagues to look at subsection C, which is what Mr. Brock's amendment is targeting. A symbol that so nearly resembles a symbol described in paragraph A or B that it is likely to be confused with that symbol. So my point is very simple. If it can be confused, then it should not be criminal. I'd like to offer an example. Some folks might say that if you take out the language inside the Canadian Tire triangle, it might resemble a symbol used by the Hamas terrorist organization. They sometimes use a triangle to indicate who the next target ought to be. God forbid. I would say I could probably get around that because that might be incitement to violence, right? Mr. Housefather, ironically, you could probably say that the Hamas triangle is incitement to violence. But I don't want to be watching a Christmas commercial for Canadian Tire thinking that it might be confused with a Hamas triangle. So may I suggest this amendment is really made in good faith to try and not be overbroad. And again, if it is likely to be confused with the actual symbol, then the word confused in and of itself should allow, not only is it confusing, it should allow for some degree of latitude and not be criminal. And also, maybe we ought to think about some first principles, as Labour Minister Bentley would probably say. We're talking about criminal conduct. And we should be very, very clear not to criminalize conduct unless it is clear that it's criminal conduct. Thank you.
Thank you, Mr. Paver. Anybody, Mr. Housefather?
Thank you, Mr. Chair. I appreciate that, and I appreciate these last two Conservative amendments, which I think have been made in very good faith. The first one, just to be clear, Mr. Chair, we had no testimony to the effect that the hammer and sickle should be included, and there's a number of others, like the Ku Klux Klan symbol. I think this has to go to thought process to add other symbols rather than just pick one and not another. So that's why I voted against that one. This one, I think, is much more compelling in terms of a discussion about it. My issue is that I think what this is trying to achieve is the opposite. I think what this is trying to achieve is that there is a terrorist group, they have their symbol, and then they manufacture, because they know that the law has prohibited the display of the symbol, they themselves distort the symbol by one tiny iota so they can argue it wasn't the symbol. And the point of, I believe, this section is to capture that. And so I would like to ask the officials who are here, presumably this was drafted by the Department of Justice, can you explain what the intention is of this section?
Please go ahead.
Thank you for the question. And so, yes, confirming that the intention really is to capture symbols that are defined in paragraph A and B. So symbols principally used by or associated with a listed entity, or the Nazi Heckenkreuz or Nazi double sing rune. If there's a slight modification, for example, if the flag of a terrorist entity is a different color background, that if it's displayed for the purpose of promoting hatred against an identifiable group, well, they're not precluded from using that offense to prosecute. So it's really on a technical basis, not excluding symbols that willfully promote hatred.
Sure, and then I'll give the floor to
Just to clarify then, the goal of the way that this is worded by our experts, presumably at the Department of Justice, is not to catch a different symbol that is not included in A and B. It is to take only the symbols in A and B where there is a deliberate attempt to distort that symbol in order to avoid or circumvent the law by the person using that symbol. It is not to caption a symbol inadvertently. Is that correct?
So sorry, that is correct. It is to capture slight variations, modifications, where otherwise that symbol, it presupposes the definition of the symbols in paragraph A and B. It doesn't create new symbols. Is that helpful? Does that respond to the question?
Yes. Yes. Thank you very much.
You done, Mr. Housefather?
Yes. Thank you. I got my
Brock.
answers.
A little bit so I can see. Thank you, Ms. Breeze, for that explanation. I don't know if it satisfies my concerns. I know that maybe Mr. Housefather is concerned, but the way that you responded to his latter question about the slight modification, did you ever give some consideration to using that language, a slight or some type of modification to an existing symbol, as opposed, which I think is more specific, which as a prosecutor might assist me in making an argument to a judge. If I were a judge, may give me some comfort in knowing that it's a different standard that I'm applying by taking a look at the real symbol, taking a look at the closely resembled symbol to see whether there was a slight modification. I think that language might be better used than the language that so nearly resembles, which I think opens up such a gray area that would there be a prosecution, I can see most cases being dismissed even on the WD standard that judges would apply. In this particular case, it would leave them with a reasonable doubt, not understanding and not appreciating a subjective analysis to that type of symbol versus an objective analysis. So I'm wondering, would you be amenable to tightening up the language to make it a little more specific for prosecutors and to assist judges in adjudicating?
So thank you for the comments. I believe that's really a policy decision, and that's not something I can speak to. With respect to the drafting of this provision, as you pointed out, the objective that you spoke to, using the words nearly resemble in conjunction with, could be confused with, is how the guidance provided in the legislation to narrow down the type of symbols that would be captured. So that was the policy intent and the legal effect of that provision.
Are you done, Mr. Brock?
Yes.
Only Mr. Babber had his hand up, that's all.
So first to Mr. Housefather's point, I think the real issue here, and this is also to Ms. Breeze, is the intent of the display. You might nearly resemble and not be exactly right, especially if you draw it and you're not good at it, and it'd be slightly off, but if the intent is a terrorist symbol, as we prescribe in this section, then it would be caught and be indeed criminal conduct, right? That's the point I'm making, is that you don't need to be concerned with the fact that someone made a slight alteration. You could think of an ISIS flag. A very good example is the ISIS flag. There are many variations of it, depending on where you're situated geographically. Some versions of an ISIS flag have more letters than others. At the same time, I think that if you're a law enforcement professional, you look at an ISIS flag and you are probably, and you know if it's well, I would hope that you know that it's an ISIS flag or not. So I'm not concerned with not being precise because it goes to intent. Whereas what this section is really doing, I think, is precisely what we're hoping, what this section hopes not to do, which is potentially criminalize behavior by inadvertence. Because what might happen here is if the intent is not there, but to draw something else, then you're now criminalizing non-criminal behavior. I think I'm right on this. Ms. Brees, what do you think about what I just said?
Please go ahead.
I think you described well how a symbol is used within the hate propaganda offense, that it is the intent to promote hatred, so the public display the symbol to promote hatred. I would, the reading of the offense again, it would not expand the type of symbols captured. It would just specify, so that I guess another way of seeing it would be that police officers on the ground would have to know with great precision that the symbols are caught by paragraph A and B. And if they get that wrong, then they are precluded from, charges or that going forward through prosecution. So that's the inverse, is that the question to the committee would be, do you want that great precision to be on law enforcement? Oh, sorry.
No, it's okay. So to your point, the problem is the word confused. If you listen to what Ms. Brees just said, and I kindly ask my Liberal colleagues to please bear with me, if I may. The problem is the word confused. What Ms. Brees is really saying, if you look at the section, if I could just redraft the section, is I would say a symbol that so nearly resembles a symbol described in paragraph A or B, that it is likely to be that symbol. That's what Ms. Brees is saying the section tries to accomplish. It so nearly resembles that it is meant to be that symbol, as opposed to be confused with that symbol. I'm right on this one.
Thank you, Mr. Bauer. Mr. Brock?
My colleague, Mr. Baber, is very confident in his legal understanding of statute interpretation. So to all the officials that are here, were any of you responsible for this final wording in sub C? Did you draft it? Did anyone draft that?
We did participate in the drafting. Sorry, Mr. Chair, if I may. We yes.
You did participate in the drafting?
Yes, that's one of our roles as Policy Council, is to work with our legislative drafters to put the minister's policy into legislative text.
So circling back to your latter comment about if there were amendments to the language, that would be a policy decision. So are you not policy decision makers at the Department of Justice, or are you just responsible for drafting legislation?
We provide advice to the minister, who gives policy direction, and then we put that into play.
Okay. So what was the genesis then of that particular clause? Did you consult with legal stakeholders? Did you consult with judiciary? Did you consult with academics, law professors, anything like that? Did it come from specific ethnic minorities? Were you persuaded one way or the other in terms of the language to be used? I'd be very interested in your response.
I can speak to this one again. And I understand the concern is specifically targeted to this particular provision. This was a provision that was developed, as Ms. Brees said, to try to close what was thought to be a risk of a loophole that could be created in the offence. Generally, we don't consult on the specific wording in a type of offence like this, although I know there were broad consultations on the broader policy objective of Bill C-9.
So what real-world examples can you give me that would support the inclusion of this clause that came from law enforcement saying we are missing an important tool in our toolbox to tackle individuals who are demonstrating on our streets, harassing religious members of communities, where they're demonstrating and they're using symbols, but we don't know whether it's an exact replica of something that is within the regs or whether there's been a slight modification. Did you get specific input, and do you have examples of cases where police officers were presented, should I or shouldn't I charge? And if they said, I can't charge because I'm missing a tool in my toolbox, is this designed to remedy that?
So thank you for the question. In terms of hearing feedback, generally feedback we have received is that police officers are looking for clear tools to address this type of conduct. A red line as to what type of symbols, for example, could be captured by this type of offense. In terms of examples of how this could materialize, again, if we take the Hezbollah flag or Hamas flag and say it were the background color were changed, and then that flag was being waved in a public place, and the person waving it was also chanting slogans that directly targeted an identifiable group. So,
but wouldn't there be criminal laws already in the books to address that particular example you just gave, an incitement to hatred?
So perhaps I could just finish this one first. So if there's a more limited definition of the symbols to A and B, then this offense would be precluded. However, to your point, there are other tools in the criminal code, other hate propaganda offenses that could potentially apply depending on the case at hand. Communicated statements for the purpose of 319 offenses include visible representations and signs.
See, here's the problem. And what I'm about to say to you right now is certainly not new to you, because if you've been following debate in the House, if you've been following debate here in this particular committee, we would love to completely reject every aspect of Bill C-9. It is a flawed piece of legislation because there are existing laws already that deal with the multitude of disturbances that we have seen over the last 2 years. So it's not an issue of a want of criminal legislation, specific tools for law enforcement. There's a lack of will from law enforcement. I have gone on a tour. I'm still touring across the country, talking to stakeholders. I'm absolutely just surprised and stunned at the number of examples of lawlessness on the streets where police have been directly told by their municipal leaders to abandon their number one sworn responsibility, that is to uphold our laws, to enforce our laws, and simply to be peacekeepers. And I'm not going to identify the city because I'm not going to out the police service, but I had spoken to a number of Jewish leaders in this particular community, and they explained to me example after example after example of protesters, pro-Palestinian, pro-Hamas protesters, specifically spitting on Jewish individuals who simply wanted to attend their synagogue, right in the presence of police officers. That's intimidation, that's assault. They've got the tools. They're not enforcing. So I really, and I appreciate your explanation. You've given me some hope that you have done your due diligence, and I would never accuse you of not exercising due diligence. This is a touchy area, but I'm just concerned that the police asking for more and more provisions to deal with thorny issues may not ultimately achieve what you're hoping to achieve, what this Liberal government hopes to achieve when we have a lack of will to enforce. The fact that we had demonstrations lasting 2 years in our country is absolutely pathetic. And it put this country in a real difficult position on the world stage. I've read and watched news reports from all over the world, and the ability for government leaders and law enforcement to take immediate concrete steps to deal with this lawlessness is something this country did not do, and it's shameful.
Yep,
and I'm
100%.
disgusted
100%.
as being a former member of the legal community that this happened in my country. So that's what I'm concerned about. If you give a provision, a new tool to law enforcement that I think is still wrought with confusion, is it up to police now to determine whether or not this is clearly in line with a symbol that falls within the regulation or something that closely resembles and that is confusing? I can see so many red flags in the mind of a young police officer, and despite leadership saying we want this, I don't think it's going to have the desired impact. All the more reason, in my view, to always seek clarity and precision and to strive for black and white language when we're dealing with anything in the Criminal Code of Canada. And I appreciate all of your responses, but I'm still not satisfied this is going to address the issues that present itself.
Agreed.
Thank you, Chair.
Thank you, Mr. Brock. I've got Mr. Lawton and then Ms. Latanzio.
Thank you. So to the officials, we know that I want to, excuse me, I want to make this less abstract for the time being, because we know in the context of the last 2 years, there have been a number of protests on Middle Eastern politics in communities across the country. Let's say a listed terrorist entity claims as a symbol the keffiyeh, and this becomes a symbol that's very associated with a listed entity. Would a keffiyeh be viewed, or could it be viewed under this legislation as a hate symbol?
I don't even know what that is. What is that? How do you even spell that?
So thank you for your question. Taking a step back, we'd have to look back on.
That's the scarf.
It's always a factual analysis, correct? And so the test here established in the provision would be, is it principally used or associated with? And so that would be, again, showing there had to be a close nexus between the group, the listed group, and the symbol.
Right.
I can't provide a response as to yes or no whether that symbol would be associated. It really is a determination, again, for law enforcement based on available evidence, and I think that's as far as I can take it.
Yeah,
but by your answer, you're now saying that there would be a gray area where that could be. Because you can't say no, you're basically saying that a keffiyeh could be under this a hate symbol if there was a listed entity that had associated itself with that symbol.
So if, based on available evidence, the facts at hand, it would be demonstrated that that symbol is principally used by and associated with the listed entity, and that's only a determination that can be made by law enforcement and prosecutors after a full investigation. Perhaps, but it's not a symbol. I cannot say today whether factually that is principally used by or associated with a listed entity. That nexus is a factual determination.
Iran has been acknowledged as a state sponsor of terror. Could waving an Iranian flag attract the same scrutiny? Could it be viewed as a hate symbol? Sorry, that was to the officials.
Can you repeat the question? Sorry.
Yeah, so Iran has been acknowledged as a state sponsor of terror. Could an Iranian flag be captured by this definition as a hate symbol?
So Iran is not a listed entity under the terrorism listing regime under the criminal code.
So when we talk about like symbols, and I realize we are discussing one particular amendment here, but we have to look at various points C-9 in its totality. So if you'll indulge me, Chair, I do have to ask about other parts of the bill here, such as
Can I just
attorney.
interrupt you for 1 sec? There's a lot of conversations going on around the room, so I'm having trouble hearing Mr. Lawton and the witness, so if people don't mind. Go ahead, Mr. Lawton, sorry.
Okay, just come back.
So, sorry, we have to look at other aspects of Bill C-9 here, in particular the removal or potential removal of Attorney General consent for laying charges. And the reason I bring that up is because you in your previous answer, Ms. Breeze, mentioned law enforcement discretion as being a key part of this. So how do we, and if this falls outside of what the Department of Justice is able to comment on, I understand, but how do we expect law enforcement to make these calls? Sometimes this comes down to, as Mr. Baber alluded to, nuances in the Arabic language that might not be known. Sometimes it comes down to, very technical details. In some cases, there is complexity to what is on the list of terror entities in the first place. So I'm just wondering if you could explain how these things would intersect with this section, and with that in mind, why we're talking about trying to remove ambiguity here.
Thank you for the question. So caveating, this is not my expertise. I'm not in law enforcement. But we would assume that police have tools. They have training to be able to identify. You have special counterterrorism units, for example. And so there are tools, even publicly available, databases of symbols. So again, relying on that expertise of the police, their tools, their knowledge, this is how that factual determination would be made. And I would also like to always bring it back to whatever the symbol is. If you've established that the symbol meets the definition in the offense, again, it all has to be considered within the broader offense. Again, the willful promotion of hatred against an identifiable group.
So we heard testimony from, I can't recall her names precisely, but it was a lawyer with the Canadian Civil Liberties Association, in which she posited that this section, unamended, basically amounts to a strict liability offense, where the act of displaying the symbol itself, irrespective of motive, is going to be an offense. And I just want to, for clarity here, I'll read the section in question here. We are talking about page 2, lines, so page 1. Everyone commits an offense who willfully promotes hatred against any identifiable group by displaying in any public place. Now, the Canadian Civil Liberties Association's position on this was that the wording of this suggests that by displaying, that is in and of itself sufficient to say that hatred is being willfully promoted. What is your view on that?
Thanks for the question. I would respectfully disagree. I think it's quite clear that this offense, which, as you will see how it's structured, resembles the existing willful promotion offense. The display of the symbol, it's to be understood within the broader context of someone who is intentionally, willfully promoting hatred against an identifiable group by displaying the symbol. That displaying of the symbol is the communication. So it is not a straight ban on symbols, nor is it criminalizing the mere display of symbols.
My last question, did you or anyone in your department advise the government for or against the section that Mr. Brock's amendment seeks to remove, specifically the wording of resembles a symbol? Did you advise for or against that in your counsel to the minister?
So our role is always to advise the minister on the criminal law and Bill C-9 as it goes through the parliamentary process. And so within that ambit, we continue to provide advice on all matters related to the bill.
So, sorry, are you claiming or disclaiming responsibility for that wording? You can blame the minister. I won't hold it against you.
What I will say, without What I will say is that our role is to provide advice to the minister on issues relating to criminal law. The content of that advice is subject to solicitor-client privilege, and so we're not able to be more specific in communicating the advice that we do or do not give.
You are paid by Canadian taxpayers, correct?
We are.
Okay. Thank you.
Thank you. Ms. Latanzio?
Yeah, Mr. Chair. We heard testimony here at committee, including the Edmonton Police Service, and I just want to put it on record just so that it's clear for everybody. And I looked up their testimony when they came before us and their take on this whole issue of symbols. So, and I quote, the EPS also supports the additional offense of willful promotion of hatred against an identifiable group by displaying certain specific symbols like the swastika, the SS bolt, or symbols of listed terrorist entities. This section clarifies these types of symbols, but also reiterates the requirement that police establish that a suspect was willfully promoting hatred against an identifiable group in public. So I just want that to be on the record, that the Edmonton police force was very much in favor of this whole section in terms of symbols. That's it. Thank you.
Thank you, Ms. Latanzio. Anybody else on this, on Mr. Brock's CPC 7? No? Okay, so shall CPC 7 carry?
Madame Latanzio?
Against.
Monsieur Housefather? Madame Dillon?
No.
Mr. Chang?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Gill?
Yes.
Mr. Lawton?
Yes.
Mr. Fortin?
No.
Why? Why would you not want more precision?
Okay.
That makes no sense.
Thank you. Defeated. Okay, so now we are moving. Yeah,
I'm
Mr.
so confused,
Baber.
man.
Thank you, Mr. Chair. I'd like to move an amendment to the same section, specifically amending Clause 4 on page 2, line 6 only, by deleting the words confused with that symbol and substituting the words a symbol described in A or B.
Can you read out the whole section, the amended section?
Yeah. So the amended section will be a symbol that so nearly resembles a symbol described in paragraph A or B that it is likely to be a symbol described in A or B.
Okay. Everybody understand that? Mr. Fortin?
No.
Translation.
I agree.
Chair, can we just have it done in French and in English so that everybody can appreciate the amendment on the floor?
Okay, so
Point of order.
Sorry, was it Mr. Lawton?
Sorry, I don't believe that Ms. Latanzio heard Monsieur Fortin, but he said he agrees with it. So I believe he understands it.
All right, well, she's entitled to make the request.
No, I know.
on her
I
own
just
behalf.
didn't believe she heard that, Chair. That was
Okay,
yeah.
fair enough, okay.
So
Okay.
suspend for a couple of minutes?
I was just going to say, why don't we suspend for a moment, yeah.
Why?
So, one second. We don't need to, I would propose not to suspend if there is a will on the part of the committee to stand my amendment down and to come back to it. It just, I'm in for a technical problem in that once we move past this clause, I'm unable to, which is why the time is urgent, but I don't want to hold up the committee.
Why don't we just suspend for a few minutes just to clarify this, and we'll come back.
Okay.
All right, so suspended.
Okay, so we'll come back to this right away. So the vote on the opposition motion for the pipeline brought by Mr. Pierre Poilievre is in about 25 minutes or so. So they will suspend again in 25 minutes, and they will go to a vote. Now, in the meantime, we can tune into the House. Yeah, we can tune into the House because 2 other committees are in camera. So we'll just tune into the House for a few minutes while we wait.
Focus the assessments on the most critical
Because as you can see, they're debating it, and then it goes to a vote.
End, in order to inform mitigation strategies and decision making. It will also be up to the federal government to provide guidance to proponents on early and meaningful engagement with Indigenous peoples to address areas of concern well.
Also, I just want to make one quick comment on the committee. You guys know I usually never like to overtalk anybody, but this is a Liberal we're listening to right now, so I imagine you're not going to be too messed up or mad if I say anything. My opinion on free speech, and I've said this before, is that free speech is like an apple. And if one side of the aisle starts taking bites out of the apple because they don't like this or that, and then the other side, whether you're left or right, starts taking bites out of the apple becomes less than an apple. And I take the stance that freedom of speech includes all speech. It might be speech that you disagree with. Now, the area where it becomes criminal is if I'm actively, which is in the criminal code already, I don't think it needs to be changed, is that if you're actively promoting violence against a certain group, then like in a very identifiable group, like let's just say I don't, for example, this is hypothetical, but let's just say I didn't like all straight white men or something like that, and then I wanted them all to be eradicated. That would be a violence that I'm advocating against a very specific group, where they're trying to now add symbols as an issue and change the definition of hate speech, where it also governs not just the intent, but the thought of the intent. So it's a little bit broader of a paintbrush, but then it gets a little bit more narrow when it comes down to symbols. And like Andrew Lawton said in the committee, we heard him say this. If somebody in his riding mowed a swastika on their lawn, and they were arrested for that because there was the intent that was specifically intended to be promoting willful hatred, right? So once you start, I think personally that's a little bit too far. I think the guy should have just been told to mow his lawn or whatever, but I don't promote going around showing the swastika in public, but I guess because it is able to be seen in public from the street, that's where he's pushing the boundaries there. I know you can have that flag in your house. That's totally legal, but it's when you're out on the street and you're promoting it, willfully in public, that's where it becomes a criminal issue. So I personally take the stance where as long as it's not advocating violence, you're more than happy to have your opinions. I don't have to listen to your opinion or like it, but that doesn't mean that I think you should be in prison for, 10 or 20 years or whatever the law says, right? So anyway, I won't keep it any longer than that. We'll get back to perfect timing because the Liberal just ended. So.
The Honourable Member for Skeena, Bulkley Valley.
Thank you, Mr. Speaker. And the member mentioned his community's involvement in the jurisprudence. My band was involved with the High Court case in 2004. We intervened. And I just want to ask the member, through the Speaker, of course, 8 months of negotiations on the MOU, and there was no involvement of First Nations. The table they've set up is a tripartite table between Alberta, BC, and federal government. Again, they excluded First Nations. When will the respect for Aboriginal rights and title start with this Liberal government?
The Honourable Parliamentary Secretary to the Minister of Environment.
Thank you, Mr. Speaker, and I thank you to my colleague. I've known the member opposite for many years, and I know that he's done great work for his community. I know that this government respects Aboriginal title and rights in this country. I do know that those conversations are going to be important as we move forward, as we go towards major projects in this country. And I'd like to ask the member opposite myself, who represents many of those coastal First Nations in northern western British Columbia, if he goes and speaks to them about how they want him to vote on the MOU.
Questions and comments? Questions et commentaires. L'honorable.
The Honourable Member for Rimouski, La Matapédia. Thank you, Mr. Speaker. We see that the Liberal government just wants to do what it wants. The Prime Minister wants to manage the state like a big board of directors. But here are the facts. The Assembly of First Nations asked the federal government to renounce their MOU with Alberta. Other voices in the government, experts on carbon neutrality, well, some members of that have quit because the government isn't listening to scientific experts. So we have a government that's not listening to First Nations. It's not consulting First Nations. It's not consulting scientists. Who are they not consulting as well? Canada's chief scientist. I asked questions to her when she came to committee, and she said that the current situation is one where the government is trying to skirt every law of the land. It's a nightmare, she said. So my question to my colleague is as follows. Does he still believe in science? Does he still believe in climate change? Or do they just want to become conservatives?
Honourable Parliamentary Secretary to the Minister of the Environment.
The short answer is no, I do not want to be a conservative. The long answer is I do believe in climate change. I do believe in Aboriginal title rights, and I do believe in the respect to come and speak in meaningful consultation and to meet with them, and this side of the House will continue to meet with them in person when at their convenience so that we can make sure that they are fully on board collaborating with any future project. Thank you, Mr. Speaker.
The hell's going on
Questions
with the House?
and comments. The Honourable Parliamentary Secretary to the Minister of Industry.
Thank you, Mr. Speaker. I think we're...
Okay.
Speaker.
House is having some nice tech issues
Questions
today.
and comments. The Honourable Parliamentary Secretary to the Minister of Industry.
Thank you, Mr. Speaker. I think we're...
Yep, there it goes again. Maybe we can just go back to staring at a...
my First Nation for...
Staring at a suspended screen.
Of my First Nation for my home riding of Vancouver Quadra. And I've watched over the years as my mother who was chief, as my grandfather who was chief, as my uncle who was chief, have further succeeded in making sure that our interests were always first and foremost. And this government on this side has made great strides in ensuring that we respect Aboriginal title and rights. I sat on the other sides of the table, and I know that I've spoken with many people on this side of the table. That's why I'm comfortable for being on this side of the table, because first and foremost, Aboriginal title and rights will be respected on this side of the government. Thank you.
Questions and comments. We have time for a very short one. The Honourable Member for Sandwich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable colleague for Vancouver Quadra, but I'm troubled that UNDRIP was excluded from reference in Bill C-5 when they said laws can be broken to build things fast. I'm very troubled that the MOU doesn't reference UNDRIP to say we will, in clear language, respect free, prior, informed consent.
The Honourable Parliamentary Secretary in 25 seconds or less.
Thank you, and thank you to my colleague from Sandwich Gulf Islands.
Oh, thank
and that
God,
is
committee's back. We don't have to listen to this anymore. It says it's back. Should be any minute now. Let's go back to the House for a sec.
why in my speech today I did indicate that free, prior informed consent is something that we will see.
Okay, great. It's back. I was a little bit early.
As a further revised change to the initially proposed amendment. So the amendment has been unofficially amended. If we could please hear the new version and also in French.
You took the words right out of my mouth.
Thank you.
Thank you, Mr. Chair. I will read the paragraph C. A symbol that so nearly resembles a symbol described in paragraph A or B that it is likely to be a symbol described in paragraph A or B. In French, en français, ça fait un symbole à ce point semblable à un symbole visé aux alinéas A.
Sorry, let me change it to English.
To those described at paragraph A or B, similar to one of those symbols described in paragraphs A or B.
I appreciate an opportunity to weigh into this, and I appreciate the fact that the committee is entertaining this amendment at this time. I am very concerned with the voting down of the Brock amendment that Clause C will remain in its present form and will therefore criminalize, should this legislation pass, a symbol that so nearly resembles a criminal symbol that it is likely to be confused with that symbol. What that will do is it will confuse law enforcement,
Yeah, exactly.
confuse lawyers, and also potentially get someone who did not mean to display a symbol referred to in paragraph A or B, but did so, and that depiction was confused with the symbol in A and B, and you have a otherwise innocent person charged with a criminal offense. I am mindful of the fact that, intent probably factors into this a little bit, so there may be some grace. But if I may, I refer to the previous Liberal minister who taught me criminal law. I'm reminded of Professor Graham at the University of Western Ontario, one of the leading jurists in our country on statutory interpretation. And I remember first week of school, first week of statutory interpretation, he told us about the mushroom case. And I apologize that I'm unable to cite the name of the case, but the proposition was simple. He asked, is mushroom a vegetable? And he said, well, look, I have a lot of experience ordering vegetarian pizza, and when I want a veggie pizza, I get mushrooms on it, so I would think that mushrooms are a vegetable. Well, the issue became prevalent vis-a-vis the question of whether mushroom growers ought to be paid minimum wage. And the case turned on the fact that if they are vegetable growers, then employers would be exempt from paying minimum wage as prescribed for vegetable growers. And if they're not vegetable growers, then there would be a mandate to pay them minimum wage. Mr. Housefather seems to think he might recall what I'm referring to. And so the case turned on the fact, the statutory interpretation turned on the fact that, well, we know that mushrooms are not really vegetable, they're fungi. But mushrooms were grown inside greenhouses as opposed to, outdoors, because those were commercial mushrooms. And as a result, the court asked, what is the intention behind the legislation? And that is, well, sometimes due to weather elements or the industrial carbon tax, the cost of mushrooms might be very prohibitive. But when you have all sorts of weather events, you might lose your crop. And so growers would be given some latitude not to pay minimum wage. However, because mushrooms are grown in greenhouses, then the grower doesn't have that problem. The mushrooms are not subjected to the elements. And as a result, the annual crop would come in and the grower would sell his mushrooms. And so there would be no need to exempt the mushroom grower from the application of the minimum wage. And so the question is, are mushrooms vegetables? The answer was, look at the intent of the legislation. The intent of the legislation is to exempt those that are risking losing their crops. The mushroom grower will not, because it's in a greenhouse. And as such, there is no need to exempt them from the application of the minimum wage, and not even answer the question of whether mushrooms are vegetables. So in that spirit, I appreciate the latitude and the accommodation. I think it's very important that the intent of this legislation is clear. We, conservatives, tend to err on the side of caution, not only when we talk about moving issues that might be transformational without thinking it through, but we want to be very conservative in the application of criminal law because we preserve charter values, we preserve the presumption of innocence, and we certainly don't want a law that would be overbroad. As presently outlined, the law might criminalize conduct that it doesn't mean to criminalize. That is why my proposal that the conduct that the symbol displayed need to be so nearly resembling a symbol in paragraph A or B that it is likely to be the actual symbol referred to in A and B eliminates that ambiguity, and therefore, I think accomplishes what this section intends to accomplish. I'm grateful to everyone on this committee for entertaining this seemingly small change. I think it might actually save law enforcement a lot of time, but deny criminal lawyers an ability to argue the statutory interpretation of what this committee has otherwise intended. Thank you.
Sorry, apparently there was a slight modification to the translation.
Merci, Monsieur le Président. Simplement, je vais relire la...
Mr. Speaker, I'm going to reread the French version. We just got the translation. A symbol, so similar to a symbol mentioned in paragraphs 1 and 2, to be confused.
Okay. We're good with that? Okay. Mr. Lawton, did you have your hand up?
Yes.
Yeah.
So just for context here, and I appreciate my lesson in statutory interpretation from my colleague, Mr. Baber. I've learned a lot, and I'm now hungry. The amendment, I think, look, it doesn't go as far as the original amendment, but the committee decided to vote against Mr. Brock's approach, and that's the way the mushroom bounces or something. But I do want to ask our officials, with the further amendment that's been put on the table, does this ameliorate your concerns that you raised in respect to the first attempt at this from Mr. Brock? No, ameliorate, mitigate. No, ameliorate.
Ameliorate.
I heard right.
We need statutory interpretation.
Ameliorate the concern.
See, we're all learning things today.
So I want to be helpful. When I spoke earlier, I was pointing to the policy intent and the purpose. Mindful that I can't provide advice on this amendment. Is there a specific question with respect to?
I'll rephrase it. Do you believe that the amendment that has been put forward by Mr. Baber keeps with the spirit of the policy in that section of the bill?
My mic is on.
There we go.
Again, I think that puts us in a bit of a difficult position to be able to respond directly to your question. It is certainly if the committee thinks that amendment is consistent with the policy intent of the bill, then we would invite you to proceed with your meeting. I think we were clear, and Ms. Breeze was clear as to the original policy intent of the language. This would maybe narrow it slightly. But the provision would remain on the books to provide maybe some support to Crown prosecutors and police who are looking for guidance on what symbols would fall under the offence.
Okay, I don't want to do the thing that I'm sure frustrates people. So what you're saying is, because I legitimately do not want to put words in your mouth, but would you view this amendment as diverging from the policy intention and the legislative goal of the section as it is? Because that's really what I'm asking here, is do you believe that this amendment is fundamentally altering the policy direction? So do you think this is a divergence from the intention that you and or the Minister of Justice had when drafting this section?
Again, trying to be helpful, yeah. I think the question is it the committee's intent that it change the policy which the department has shared at the outset?
Sorry, I don't mean to cut you off. I'm trying to not put you into that realm. I'm trying to ask. Let's go back to first principles here. What is the policy intention of that particular section?
This was your.
What is the direction that your department was given that led to that?
Perhaps what I can do is just speak to technically what this amendment would do, as opposed to the policy intent behind the amendment that is being proposed.
Sure.
So if I were to read, for example, described A or B, that is a symbol, that is likely to be a symbol as described in A or B, I believe is, did I get that correctly?
Yes, that is likely to be a symbol as described in A and B.
So is likely to be a symbol in A and B would, at first glance, appear to mean the symbol described in A or B.
Mm-hmm.
So there's not, une marge de différence, I don't know how to say, between C. So you're basically, C would capture a symbol that resembles, that is a symbol that resembles A and B, and that is likely to be A and B. So again, there's not much difference, I would say, between A, B, and C. That's plain reading.
Realizing you are not in law enforcement, but if this were to come before a courtroom that you were working in, would you view this as being an amendment that provides greater clarity in how to interpret that offense?
I think I'm delving beyond my role as a technical expert in that type of question. What I can speak to, again, is the technical aspects, which I've just done. And if that is the committee's desired intent, interpretation, then I think that the committee would be best able to respond to whether that empowers law enforcement to better understand the provision.
Okay. Thank you.
Okay, Mr. Lawton, you're done? Mr. Brock?
I'm moving a sub-amendment to my colleague, Mr. Baber's amendment. I do this not out of disrespect to Mr. Baber. We're trying to come up with a solution here that will satisfy everyone at this particular committee and also addresses the overall concerns that I had at the outset in terms of my original amendment that was voted down. And I also appreciate the input from both Ms. Wells and Ms. Breeze. And I hope you are not concerned about us questioning you. I appreciate you can't give us legal advice. You can't provide us with a legal opinion. You are here to help. But what I'm picking up when I read between the lines is some degree of hesitation. I don't think you would support or not support a potential amendment. It's to the will of the committee. So I think there is a compromise here, and I wish everybody would pay attention and to hear me out on this. I propose that we take the existing language in sub C to now read a symbol that so nearly resembles a symbol described in paragraph A or B, period. No further explanation beyond that. And I think that provides a very clear direction to law enforcement. We still get into interpretation issues if this were a trial in terms of a subjective or objective analysis, but we don't have to worry about that. That's for a different day and a different discussion. But I think it clarifies your concerns, Ms. Breeze, that the amendment brought by Mr. Baber may be more confusing than clearer. So that would be my sub-amendment, and I don't have it drafted, but I can certainly do that when the bells are ringing. I understand that we are not providing unanimous consent. I think there's a will of both the Liberal team and the Conservative team to actually attend back at the House for the purposes of voting, and in the interim, I can actually draft this in both official languages.
I think you're doing the opposite of what you want to do with your amendment.
Mr. Housefather?
I suppose that is not a sub-amendment that would be receivable on Mr. Baber's motion, which substituted words. Now you'd be cutting off the entire sentence that Mr. Baber had substituted. So I don't believe that's a proper sub-amendment on Mr. Baber's motion. I'd ask you to rule that way, Chair.
Of course it is.
I'm right on that.
All right.
Technically speaking,
Okay, so the bells are ringing.
Okay, there we go.
Yeah,
We
the
got
bells
vote
are
coming up.
ringing, so we are going to suspend. Hopefully somebody's going to listen to me here. Mr. Barber, Mr. Barber, please. The bells are ringing. We're going to suspend. I think I have a solution that I might get us through this, which we can do during the break. But so we'll suspend till after the votes and ask everybody to be here 15 minutes after the last vote. Okay? Meeting suspended.
The tally of the vote is declared. Not after the last vote. After
Well,
the
if you want to get out of your chair, before it's, that's fine. Yeah, go ahead. By all means. All right. Meeting suspended.
Okay, perfect. This is going to be a half-hour thing, as you can see. But I've got something we can tune into in the meantime. There was MP Scheer on Vashi's show last night, which I haven't watched, and I wouldn't mind watching while we wait for the members to show up in Parliament. So let me just find this. That way we're not just sitting here staring at a blank screen for 29 minutes. I mean, we kind of already know how this vote's going to go, to be honest. We know that this vote is going to get shut down. It would just be nice to see it in person, because then that way we know for a fact Carney's not really going to live up to his MOU. Here it is.
Hi, Mr. Scheer. Good to see you again.
So I'll keep an eye on this timer. Move this to another monitor. Okay, we'll watch this in the meantime.
Great to see you. Pleasure to welcome you back to the studio. When Premier Danielle Smith signed this MOU with the Prime Minister, she said, quote, "It's a great day for Alberta and Canada." Are you saying the Premier's wrong?
Well, we just don't believe that provincial government should have to sign on to something like an increase in the carbon tax. A Conservative government would not impose that type of condition on a province. We're pro-energy. We don't believe that that the government should make it harder to get things built. We think the government should make it easier to get things built, set the rules and make it apply to everybody. So what we're saying is that two things. One, there are conditions in this bill that aren't necessary for the construction of a pipeline. And the second thing is we don't believe Mark Carney's actually serious about getting it done, because he's got this very complex and complicated MOU with lots of conditions, and then he immediately goes out and says these are necessary but not sufficient, meaning that even if the government of Alberta clears all these hoops and hurdles, that he still might say no. He said the British Columbia Premier gets a veto, and now we're hearing rumors today that they're going to vote against their own MOU tomorrow in a Conservative motion. So that's why we're saying that this MOU is not great. We believe that the federal government should be partners in prosperity, helping provinces get to yeses, not saying one thing in Alberta and something completely different in Ottawa.
A couple of different things. So I didn't hear unequivocally that BC from the Prime Minister has a veto. He certainly talked about BC needing to agree, but I've asked his ministers on multiple occasions because of what your party has brought up. Does that mean that there is effectively, not even constitutional, but effectively a veto? And everyone I have asked has said no, that's not the case. Second of all, what your party seems to be inferring by putting this motion forward is that there is ambiguity, right? A lot of ambiguity within the MOU. Again, I'll put to you, the Premier doesn't seem to indicate at any juncture that that's the case. And even when you read through the text, like I would have guessed also that it would be ambiguous to allow for multiple different possibilities. But it is incredibly specific. Construction of one or more private sector constructed and financed pipelines with a route that increases export access to Asian markets as a priority. It is agreed this pipeline would be in addition to the expansion of the TMX pipeline. Like, that is not ambiguous.
Well, you are right about the deliberately misleading Canadians on terms. And you talked about the veto. Mark Carney is getting famous for this, by the way, saying something and then contradicting himself in the next sentence. So when you say that a premier has to agree for it to proceed, that's a veto. I mean, you can call it something else. You can say you're trying to dance around the language. But if at the end of the day, David Eby refuses to approve, refuses to sign off, Mark Carney is saying that his approval is necessary. So if that in fact blocks the pipeline from going ahead, then he's effectively got a veto. I don't think Canadians want to play semantics about word definition. I mean, I love going into word origins and things like that, but Canadians want clarity, they want certainty. And if you look at the entire MOU, there's a whole lot of conditions on there that Conservatives would never impose on the people of Alberta or the government of Alberta. And he immediately comes to Ottawa and says, even if the government does all this, even if the government of Alberta does all this, he says it's not sufficient. It still might not go ahead. And then we hear, Liberal MPs saying that it'll never get built. So what our motion is attempting to do tomorrow is to provide that clarity, give Liberals an opportunity to vote for their own MOU. We've lifted language right from the MOU. If they vote in favor, then that would send a signal that they're at least going to back up what they sign on to. If they vote against it, or if half their caucus votes against it, it's going to be sending a very different message to Canadians. And what we're trying to show Canadians is that Mark Carney has spent his entire life fighting against energy development. He wrote a book called Values, where he defined himself as a human being and talked about the need for higher carbon taxes and leaving up to 50% of Canada's natural resources in the ground. So he's trying to reinvent himself and turn him into something that he just has never been. And the motion tomorrow is an attempt to provide Canadians clarity about who Mark Carney really is.
But is it an attempt to be political because it is an issue that that their party doesn't fully agree on, and to exacerbate those differences when ultimately the Prime Minister did sign this MOU, right? Like, I take your point on things he said in the past. I certainly have questioned him about that. But he has gone further than I can remember any federal Liberal going in putting down in paper in very explicit and specific terms exactly what this pipeline would look like, where it would go, how much extra oil beyond what exists right now in the capacity to export it would entail. Like, again, this is not ambiguous. He is signing his name to it.
Well, if you look at everything that's happened since the MOU was signed, there's a lot of ambiguity. And if Mark Carney had to come out, sign this MOU and said, I look forward to the day shovels are in the ground and I support pipelines, he still hasn't even said that. Mark Carney still hasn't even said that he would like to see this proceed. He just says that these are conditions that are necessary but not sufficient. That's a very clever Liberal politician phrase to basically say two things at the same time, that it might happen if you do this, but it might not happen even if you do all that. It's just incredibly confusing. If the Liberals had to come out of this MOU signing with clarity, with full-throated support for the men and women who work in Canada's energy sector, excited about the prospects about opening up Asian markets to Canadian energy, we'd probably be debating a different motion tomorrow. But the fact that you've got Liberal ministers saying something completely different than what the Prime Minister said when he was in Alberta, the fact that
but doesn't your caucus not agree on everything? Like, isn't that a part of a democracy? Like, there's not everyone is going to feel the exact same way. Ultimately, it's the person in power who's going to decide the direction of the party and the government.
But even Mark Carney and Cabinet can't even provide that assurance to Canadians that if the government of Alberta succeeds in clearing all these new hoops and hurdles and all this the new conditions that they've imposed, they still can't even clearly say whether or not a pipeline will actually get built.
But that's what the MOU does say.
Yes, but they've contradicted themselves immediately afterwards. That's the point. They haven't been able to clearly even stand behind their own MOU. The ink it still isn't dry yet. And you've got senior Liberals talking it down, senior Liberals saying it'll never get built. So this is an opportunity for Parliament and for the House of Commons, for every MP to clearly stake out where they are. Don Davies and the NDP, very clear. They're against pipelines. Conservatives, very clear. We support our energy sector and want to see Canada develop it more and get off of the dependence of the U.S. market. Mark Carney and the Liberals try to say two things at the same time. One thing in Alberta, something completely different in Ottawa. We just want some clarity so that Canadians can hold this government to account.
There's enough clarity in this that the AFN a week ago voted unanimously to demand the withdrawal of the deal. There's enough clarity in this that BC is very upset about the posture of the government there, the NDP government there, about the posture the federal government is taking. Like, enough clarity exists for the people who oppose this potential pipeline, which doesn't even have a private proponent at this point, to voice that opposition and to make motions and vote on them. Why isn't that enough for you?
Well, because the people who oppose pipelines will always oppose pipelines, no matter what you sign and no matter what you call it or where you plan it. Canadians want to get off of the dependence of the U.S. market. They want to be able to sell our oil and gas around the world. The men and women who would like to work in those fields would like these projects to go ahead. Conservatives are on their side. Mark Carney is trying to placate both groups. He's trying to get everybody who opposes pipelines to say, hey, don't worry, this thing will never get built, and then hold out the fig leaf to Canadians who do want to develop our oil and gas, that there's this murky possibility. If the government of Alberta gets everything right, then maybe. And what Conservatives are trying to do is say, no, our job is to hold the government to account. They've got this MOU. We've taken the words right out of that, and now we're going to see where every single MP stands on this issue. I think that's the role of the opposition, is to provide that clarity to Canadians and to draw that out. This should be the easiest decision in the world for a Liberal. Your Prime Minister just signed off on this MOU, 2 weeks ago? Do you support it or not? That's the question tomorrow.
Except for you did use some of the language, you didn't use all of it. I know that you're critical of the kind of bargain that's in there, the stuff that Alberta has to do in increasing the industrial price on carbon in exchange, or the carbon capture projects, for example, in exchange. But that stuff is part of what predicates the support from the Prime Minister, it would appear, and that's certainly what the Premier signed on to. You didn't include that stuff in the motion that the MPs will vote on. You very specifically just included the part about supporting a pipeline. Is it disingenuous, right? Like, are some MPs only able to support that pipeline because they feel the other side is being taken care of as well? No,
because the point of the MOU, Mark Carney didn't go and sign that MOU to build a ring road around Calgary. He didn't go to the MOU to, make other investment, other infrastructure types of things. He went to Alberta to sign a deal to get with the outcome of this MOU to be a pipeline constructed. That's what he claims. So what we're just asking Liberal MPs is, do you support this in principle? Do you support the idea of getting to a yes where a pipeline could one day be built?
But what if they support it predicated on additional measures to reduce emissions? Like, that's not included in there. You only put part of it.
But there's nothing in the MOU that contradicts any of that. So there's no problem for a Liberal to vote in favor of that part of it, because it's not, we're not asking him to denounce any other part of it. It's a little bit like if you wanted me to buy your house and I say, okay, well, there's some conditions, maybe you got to change the paint color and change the landscaping in the backyard, and you say, okay, so, but in principle, do we have an agreement that you will buy my house? And I say, no, maybe not. Do these things and we'll keep talking, maybe. I mean, that's not.
But wouldn't you want to make sure the conditions are adhered to before you put out that kind of money?
Yes, but if I can't even say that, even if you did that, yes, you're right. You're absolutely right. You would want to as the seller. But what I'm saying is, Mark Carney in this scenario is the person saying, if you make all these conditions, if you do all these things I've asked you to, then maybe. Well, that's not how business works. That's not how the world works. If you can't even say in principle,
then maybe it really isn't.
But he is. He specifically said these are necessary but not sufficient conditions.
The sufficient condition is there needs to be a private proponent that comes forward, which is missing from the Conservatives' position altogether.
That's in the MOU.
Yes, it's in the MOU. That's what I'm saying.
But then he immediately went out and said, but even what he said after the MOU was signed was, even if all these things were all the, if you can imagine all the hoops and hurdles that Mark Carney has now placed on the government of Alberta to get a pipeline built, even after all of that, he's saying it's not sufficient. That's incredibly confusing to Canadians. It's sending a terrible signal to investors that, who's going to sign on to...
Have any of those investors complained so far? I've only heard positive reaction from the industry.
If you look at the energy industry, even after Mark Carney became Prime Minister...
But since the MOU?
Well, even after Mark Carney became Prime Minister, billions of dollars have gone into U.S. projects. Canadian companies are expanding their American businesses, their American projects, to the benefit of American workers and American investors. That is not a recipe for success for Canada, and that's not what Mark Carney promised Canadians. And with this MOU, he promised he would move at unimaginable speeds. And again, we don't compare Mark Carney to previous prime ministers or Justin Trudeau. We compare him to himself. We hold him to the standard that he promised Canadians. He said he would move at unimaginable speeds. The timeline in this MOU are years away, and he's put incredibly difficult conditions on this that we don't believe are necessary. And now they can't even back it up with a vote in Parliament with their own caucus supporting what Mark Carney signed on to.
Okay, I'm out of time. I have to leave it there. We'll look forward to the vote tomorrow. Thanks, Mr. Chair. Appreciate it.
Thank you very much.
Okay, so I'm just double checking. I'll show you guys where we're at on the vote. Vote is 16 minutes and 7 seconds. So I'm going to try and find... The House is obviously suspended. Let me find us something else to watch in the meantime. Bum, ba-da-dum, bum, bum. Okay, MPs commented on the motion, so this was only less than an hour ago.
I just wanted to point out the Conservatives have amended their own motion. They obviously know that their position is improvised It's a train wreck and cannot pass this Parliament. On the other hand, the government has a memorandum of understanding duly negotiated with the province and the Premier of Alberta, and which acknowledges the discussions that must happen with British Columbia, with rights holders, with First Nations. So we're obviously very, very confident and comfortable, happy with our position. It's unfortunate that the Conservatives don't seem to be happy with theirs, so we'll be voting against their amendment as well as the main motion.
Est-ce que M. Guilbeault peut rester au caucus libéral après la lettre qu'il a publiée dans les journaux ce matin?
Moi, j'ai beaucoup d'estime pour M. Guilbeault.
We skip the French.
OK. Sur le mémoire, évidemment, c'est une négociation et nous voterons one and
vote tonight, or the Conservative opposition day motions?
Opposition day motions, unless they're confidence, don't tend to be whipped votes. No.
M. McKinnon, sur les chauffeurs à rabais, on a vu la une du Journal de Montréal ce matin. Il y a.
See what the NDP has to say.
Expanded by 30%. There is no business. Is bad. Good afternoon, everybody. Bonjour tout le monde. I'm Don Davies, leader of the NDP, and I'm joined by Alexandre Bouleris, our environment critic. And I'm here to talk about the pipeline issue, which of course is being debated in the House today. It's quite clear to the New Democrats that this pipeline is bad for the climate. It's bad for federal-provincial relations. It's bad for Indigenous reconciliation. And it's bad for the British Columbia coast and coastal communities. You know, even the former Liberal Environment Minister has been extremely clear that this pipeline will render Canada's climate goals impossible to reach. There is no business case for a bitumen pipeline at this time, as we all know that the Trans Mountain Pipeline is below capacity and
it's at like
still
80%,
can be expanded by 30%, which has not been done yet. We know that the BC coastal community has over $1.2 billion of local economic activity currently, which is being put at risk by this pipeline. There's a very, very robust fishing industry and ecotourism, and those industries are put at risk. We know that the waters off the coast of northwestern British Columbia are among the most treacherous, not only in Canada, but in the world. They are highly difficult to navigate, and the spill response capacity is virtually non-existent. On top of that, we know that British Columbia has not consented, nor have the various Indigenous nations that are going to be affected by any project. I want to conclude just on the consent issue. The Prime Minister stated in this House that any bitumen pipeline to northwestern British Columbia must have the agreement of the Government of British Columbia and affected Indigenous nations. The Energy Minister then went to British Columbia and said that free, prior, and informed consent by Indigenous nations was required, and yet the Memorandum of Understanding that was reached between Ottawa and Alberta says no such thing. So I'm going to be calling on the Prime Minister to come clean with Canadians. Is consent required for this pipeline from the affected government and the affected First Nations or not? That must be clarified before a project of this magnitude and of this critical impact goes ahead. I will now turn this over to M. Bouleris.
It doesn't matter. You don't like it anyway. So why would that
Merci,
matter?
merci, Don.
Skip the French guy.
Three quick things if
I'm
I
not
could
saying I
run
don't like
through.
French.
First,
I'm just saying I can't understand
as acting NDP leader, what do you make of the Conservatives' pipeline motion today? And their first motion and their second?
Yeah, I was going to say which one. I mean, the fact that the Conservatives had to make dramatic and profound amendments to their own motion halfway through debate, I think tells you something about their motivations. Clearly, their motion was not a serious one, set out from the beginning, raising a serious issue. I think it was an attempt to play a political game about a very serious issue. You know, this is we're talking about a multi-billion-dollar issue that has incredible consequences for people across this country. And the fact that the Conservatives couldn't get their own motion right, I think, says something about their motivations.
No.
Second, air transit pilots have voted 99% for strike action. What do you make of the possible job action? What's your view?
If it's okay, I'll turn that over to our labour critic and transport critic.
To be honest, guys, I fly back to Canada in 2 weeks, less than 2 weeks. And if Air Transat strikes, that's my flight. I'm not going to be, I really hope they don't strike so I can get back to Canada, see my family for Christmas.
For the BC Conservative Party, this is brand new, a couple seconds ago. Do you have any thoughts about Mr. Gunn running for the official opposition in Victoria?
Well, I've been watching the difficulties that the British Columbia Conservative Party has had for quite some time, and I think it's a fair description to say that they're in a bit of chaos. With Mr. Rustad's resignation, I've heard a lot of names being bandied about as potential successors, but in Canada, our political parties are robust, democratic entities, and I think that the more viewpoints that are expressed and the more vigorous and diverse leadership contest is, the better for the party. And, the NDP is having one right now federally. We have 5 very strong candidates. So I have a first row seat to what it looks like when a party has a number of different perspectives vying for leadership. So, if Mr. Gunn is interested in that, I wish him good luck.
And we've seen Kennedy Stewart start to run for Vancouver Mayor. We've seen Mr. Erskine Smith, Mr. Nackvey run for Ontario Liberal leader while remaining as MPs. Do you think that any Conservative MPs running should give up their seats or stay at this point?
Well, it's a gray area, and we've seen that happen. We saw, as you say, we've seen some, I think it was Mr. Erskine Smith and Mr. Nackvey run for leader of the Ontario Liberal Party, and you pointed out Mr. Stewart running for Mayor of Vancouver. I often think that there should be some guidelines, I think, around that, because when you're running for a different job, if that's going to compromise your ability to do your current one, I think that raises some issues. So it might be something for Parliament to look at in the future to put some guardrails and guidelines around that. Thank you. Thank you very much.
Well, let's see what this lunatic Thibault has to say.
Par rapport à la découverte
Oh, not in French.
que le gouvernement a signé,
jusqu'à maintenant, il n'y a personne qui m'a dit ça.
Of course, he only answers in French.
On dit comment MOU en français, mais le contrat avec la province d'Alberta.
Nobody really cares about the rest of this. Okay, let me see what else I can find to watch. What do we got? Timer. 7 minutes. Oh yeah, I did want to comment on this aspect right here, where Don Davies was talking about a potential reaction for an oil spill. It's very clear, and this is very well researched, very well documented, that the BP oil spill on the East Coast down past the U.S., when that oil spill happened, the marine life in that area, around in that area, actually took over 2 years, saw a very much increase in the amount of marine life and the amount of biodiversity in the area. And that's because we left it alone. That's because there was a large multi-100-kilometer radius put around it because we were afraid, obviously, for fishing in that area, that those fish would be tainted. Because we didn't fish in that area actually took a very large increase in what these climate activists would want. Now, I'm not saying, oh, let's just do a bunch of oil spills everywhere, but it's a very well-known fact that the BP oil spill was actually a positive thing. Oddly enough, was actually a positive thing for biodiversity and marine life in that area because we left it alone. But here, we'll just leave this on vote call for 6 minutes. When did this spill happen again? BP oil was in, what was it, 2010. 2010 it was, and it was off the coast of the Gulf of Mexico in the United States. And that thing spewed for like, how many days? It was like almost a year or some crap like that. But yeah, biodiversity actually took a very large increase. Mother Nature took care of itself. Exactly. That's exactly what happened. You just left it alone, and it just managed to rebound like 100 times more. That blowout was sus. Yeah, I mean, I don't know who could have not turned off a valve as somebody who's worked in the trades and has worked with gas, not oil particularly. Those are very large diameter pipes, but I mean, there's always a shutoff somewhere. How did the shutoff blow off and there wasn't a shutoff before that? How could that thing just keep gushing for like hundreds of days is beyond me. But yeah, I think we don't really have much else other to watch. We've really kind of caught up on everything. So we're just going to wait 87 days before they put the first cap on. Yeah, so like are we getting paid overtime asking for a friend? Are we, as in us in chat? I don't know. We'll see if the government gives us any more handouts. I don't get any, but we'll just leave it on this. I'll just read chat. We'll have a chatter here for 4 minutes before the vote call. We already know how this vote's going to go. And to be honest, I'm kind of reluctant to turn back into the Justice Committee. We'll see how long the Justice Committee goes for. I don't really want to go clause by clause on Bill C-9. I don't want to sit there for like up until 11:30 for like another 4 hours reading clause by clause on a bill I don't even agree with in the first place. I think we really just caught the best part of what that Justice Committee was going to be. You see Don Davies at the roast last week? Yeah, that was over 2 weeks ago. The Don Davies roast was almost 2 weeks ago now. That was when they had the press gallery dinner, and Pierre did his thing, and Don Davies did his thing. That was pretty funny. I'm not gonna lie. Don Davies saying Elizabeth May was my designated driver. I laughed pretty hard when I saw that. That was pretty funny. But yeah, I mean, we can tune back in for the Justice Committee for a little bit after the vote, but I don't think we're gonna stick around for the whole time. Dun, 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 dun. What do we got tomorrow? We got question period at 2 p.m. I don't really think there's many committees on after that. It doesn't seem like Wednesday really has anything. Yeah, Wednesday just has one committee. I don't know why they haven't scheduled more for that. Thursday has quite a bit of committees scheduled. Same with... Wait. Is that tomorrow? Is ethics tomorrow? Yeah, that will be Wednesday. Okay, perfect. So there is the ethics committee we can watch on their study of the Conflict of Interest Act. We can watch that after question period. But that's pretty much it. And then Thursday's got a few committees, and that'll be our last day for streaming for the week. And we won't come back till the new year. Refresh the page for that I know of. Yeah, I did. I didn't see that. Because it breaks it down, because the couple committees that are suspended are kind of like taking precedent. But yeah, we'll do ethics committee. The finance committee's, I think, in camera, so we can't even really watch that. But what is the industry committee has? Auditor General reports. It's just on First Nations. There is a minister in for the first hour. And then Karen Hogan's in the second hour. I still think ethics would be better than that. Ethics committee? Ethics committee. Ethics. So yeah, we'll do question period at 2, and then we'll do ethics tomorrow, and then we've got some stuff for Thursday, and that'll be it for the week. And that'll be it until the new year. The Justice Committee was talking about this today, that they would like to get some meetings up in the winter break, but I don't think that'll happen because it is a Liberal chair. So we might see some OGO ones come up or some ethic ones come up. We'll see. If there are any committees that do just so happen to pop up over the winter break, we will definitely cover those right away. But what do we got? 5 seconds here on the vote call, and then we're going to see how this goes. We already know how this is going to go, though. Ethics Committee, we get the Baron again. Who's the Baron? Vote call, vote call, vote call. Shouldn't be a winter break. Can we get a trade deal? Yep. Yeah, I don't think they should get like 6-7 weeks off. It's ridiculous. I wonder, does Smith think the MOU is a stepping stone till Pierre wins? No, I think Smith got a lot of her concessions that she wanted, so she's probably happy with some of them. Turn this up a bit.
The question is as follows. Mr. Upal, seconded by Mr. Halan, moved that the House, A, take note of the Memorandum of Understanding between Canada and Alberta. May I dispense? A, of November 27th, 2025, and B, support the construction of one or more pipelines enabling the export of at least 1 million barrels a day of low-emission Alberta bitumen from a strategic deepwater port on the British Columbia coast to reach Asian markets, including through an appropriate adjustment to the Oil Tanker Moratorium Act, while respecting the duty to consult Indigenous peoples. Monsieur Poilievre, appuyé par Monsieur...
Mr. Poilievre, seconded by Mr. Scheer, move the following amendment, that the motion be amended by inserting after the word including the word I, and by adding after the words Indigenous peoples the following. 2. Greenlighting the world's largest carbon capture, utilization and storage CCUS project for the purpose of making Alberta oil among the lowest carbon intensity produced barrels of oil in the world. 3. Providing meaningful opportunity for Indigenous rights holders to participate in consultation processes and economic opportunities through Indigenous ownership, partnerships, and benefits. 4. Engaging with British Columbia immediately in a trilateral discussion on the pipeline project and during the potential development and construction of the bitumen pipeline referred to in the MOU, and to further the economic interests of BC related to their own projects of interest that involve the province of Alberta, including entities and Canada working with BC on other projects of national interest in their jurisdiction.
The 10-minute period for members voting electronically has started, and the House will now proceed to the vote for members participating in person. All those in favor of the amendment will please rise.
Mr. Scheer. Mr. Doherty. Mr. Doherty. Mr. Schmale. Mr. Schmale. Mr. Brock. Mr. Brock. Mrs. Block. Mrs. Block. Mrs. Thomas. Mrs. Thomas. Mr. Dentel. Mr. Dentel. Mr. Upal. Mr. Upal. Mr. Halan. Mr. Halan. Miss Lewis Haldeman Norfolk. Miss Lewis Haldeman Norfolk. Mr. Chong. Mr. Chong. Mrs. Kuzi. Mrs. Kuzi. Mr. Chambers. Mr. Chambers. Mr. Albus. Mr. Albus. Mr. Caputo. Mr. Caputo. Mr. Small. Mr. Small. Mr. Major. Mr. Major. Mr. Strahl. Mr. Strahl. Monsieur Brassard. Monsieur Brassard. Mr. Moore. Mr. Moore. Monsieur Bertol. Monsieur Bertol. Mr. Duncan. Mr. Duncan. Mr. Workington. Mr. Workington. Mrs. Cramp-Nyman. Mrs. Cramp-Nyman. Mr. Canna. Mr. Canna. Mrs. Roberts. Mrs. Roberts. Mr. Morin. Mr. Morin. Mr. Ross. Mr. Ross. Madame Vien. Madame Vien. Mr. Cooper.
Mr. Cooper.
Mr. Lloyd.
Mr. Lloyd.
Mr. Van Pupta.
Mr. Van Pupta.
Mr. Kelly.
Mr. Kelly.
Monsieur Généreux.
Monsieur Généreux.
Monsieur Gould.
Monsieur Gould.
Mr. Viss.
Mr. Viss.
Mr. Tucker.
Mr. Tucker.
Mr. Steinley.
Mr. Steinley.
Mr. Zimmer.
Mr. Zimmer.
Mr. Lobb.
Mr. Lobb.
Mr. Baldinelli.
Mr. Baldinelli.
Mr. Waugh.
Mr. Waugh.
Miss Rood.
Miss Rood.
Mr. Ho.
Mr. Ho.
Mrs. Falk Battleford's Lloydminster, Meadow Lake.
Mrs. Falk Battleford Lloydminster, Meadow Lake.
Miss Gladue.
Miss Gladue.
Mrs. Goodridge.
Mrs. Goodridge.
Mr. Shipley.
Mr. Shipley.
Mr. Bragdon.
Mr. Bragdon.
Mr. Tolmie.
Mr. Tolmie.
Mr. Arnold.
Mr. Arnold.
Mrs. Gallant.
Mrs. Gallant.
Mr. Allison.
Mr. Allison.
Mr. Vierson.
Mr. Vierson.
Mr. Epp.
Mr. Epp.
Mr. Diot.
Mr. Diot.
Mr. Macaulay.
Mr. Macaulay.
Mr. Menegakis.
Mr. Menegakis.
Mrs. Wagenthal.
Mrs. Wagenthal.
Mrs. Jensen.
Mrs. Jensen.
Mr. Albuteyev.
Mr. Abulteyev.
Mr. Motts.
Mr. Motts.
Mr. Dalton.
Mr. Dalton.
Mr. Cram.
Mr. Cram.
Mr. Lewis Essex.
Mr. Lewis Essex.
Mr. Anderson.
Mr. Anderson.
Mr. Owl.
Mr. Owl.
Mr. Babber.
Mr. Babber.
Mr. Bailey.
Mr. Bailey.
Mr. Bexty.
Mr. Bexty.
Mr. Bonk.
Mr. Bonk.
Mrs. Borelli.
Mrs. Borelli.
Mr. Davies, Niagara South.
Mr. Davies, Niagara South.
Mr. Gill, Calgary Skyview.
Mr. Gill, Calgary Skyview.
Mr. Gill, Brampton West.
Mr. Gill, Brampton West.
Mr. Gill, Calgary McKnight.
Mr. Gill, Calgary McKnight.
Mr. Gill, Windsor West.
Mr. Gill, Windsor West.
Monsieur Groslo.
Monsieur Groslo.
Mr. Googlemine.
Mr. Googlemine.
Mr. Gunn.
Mr. Gunn.
Monsieur Hardy.
Monsieur Hardy.
Mr. Holman.
Mr. Holman.
Mr. Kibble.
Mr. Kibble.
Miss Kirkland.
Miss Kirkland.
Mrs. Conan.
Mrs. Conan.
Mr. Ruff.
Mr. Ruff.
Miss Cronus.
Miss Cronus.
Mr. Couric.
Mr. Couric.
Mr. Ma.
Mr. Ma.
Mr. Mahal.
Mr. Mahal.
Mr. Mantle.
Mr. Mantle.
Mr. McKenzie.
Mr. McKenzie.
Mr. Reynolds.
Mr. Reynolds.
Mr. Rowe.
Mr. Rowe.
Mr. Stevenson.
Mr. Stevenson.
All those opposed to the amendment will please rise.
Mr. McKinnon Gatineau.
Mr. McKinnon Gatineau.
Mr. Ali.
Mr. Ali.
Madame Diab.
Madame Diab.
Mr. McDonald Malpeck.
Mr. McDonald Malpeck.
Mr. McGinty.
Mr. McGinty.
Mr. Lightbound.
Mr. Lightbound.
Mr. Robertson.
Mr. Robertson.
Mr. Bruson.
Mr. Bruson.
Monsieur Champagne.
Mr. Champagne.
Miss Thompson.
Miss Thompson.
Mr. Ananda Sangari.
Mr. Ananda Sangari.
Madame Michel.
Michel.
Mr. Fraser.
Mr. Fraser.
Monsieur Miller.
Monsieur Miller.
Mr. Cedar Brampton East.
Mr. Cedar Brampton East.
Miss Oljevsky.
Ms. Oljevsky.
Mrs. Valdez.
Mrs. Valdez.
Madame Pittspa-Taylor.
Pittspa-Taylor.
Mr. Blair.
Mr. Blair.
Mr. Wilkinson.
Mr. Wilkinson.
Mr. Fragiscatos.
Mr. Frangiscato.
Mr. Fuhrer.
Mr. Fuhrer.
Mr. Vancouverden.
Mr. Vancouverden.
Miss Sahota.
Miss Sahota.
Mr. Belanger. Desnati Mississippi Churchill River.
Mr. Belanger. Destination Mississippi Churchill River.
Miss McKnight.
Miss McKnight.
Miss Chartrand.
Miss Chartrand.
Mr. Gerritsen.
Mr. Gerritsen.
Miss Alty.
Miss Alty.
Mrs. Golmasty.
Mrs. Golmasty.
Mr. Sarai.
Mr. Sarai.
Mr. Long.
Mr. Long.
Mr. Zericelli.
Mr. Zericelli.
Madame Chanette.
Madame Chanette.
Miss Latenzio.
Miss Latenzio.
Mr. Housefather.
Mr. Housefather.
Mr. Noor Mohammed.
Mr. Noor Mohammed.
Madame Minal.
Madame Minal.
Mr. Guilbeault.
Mr. Guilbeault.
Miss Jazik.
Miss Jazik.
Mr. Beach.
Mr. Beach.
Miss Scroll.
Miss Scroll.
Mr. Duguid.
Mr. Duguid.
Mr. Erskine Smith.
Mr. Erskine Smith.
Mr. Fisher.
Mr. Fisher.
Madame Châtel.
Madame Châtel.
Mrs. Romanado.
Mrs. Romanado.
Mr. Lewis Kitchener-Conestoga.
Mr. Lewis Kitchener-Conestoga.
Mr. Grant.
Mr. Grant.
Monsieur Litao.
Monsieur Litao.
Mr. Bardisi.
Mr. Bardisi.
Madame Kayabaga.
Madame Kayabaga.
Mr. Lamoureux.
Mr. Lamoureux.
Madame Brière.
Madame Brière.
Mr. Turnbull.
Mr. Turnbull.
Mr. Kellaway.
Mr. Kellaway.
Monsieur Gay.
Monsieur Gay.
Mr. Hogan.
Mr. Hogan.
Madame Koutrakis. Miss Chi. Mr. Miles. Mr. Biddle. Monsieur Cormier. Miss Dillon. Monsieur El Khoury. Monsieur Fergus. Mr. Fonseca.
Mr. Fonseca.
Monsieur Lauzon.
Monsieur Lauzon.
Mr. Maloney.
Mr. Maloney.
Miss Suds.
Miss Suds.
Madame Desrochers.
Madame Desrochers.
Mrs. McKelvey.
Mrs. McKelvey.
Mr. Gasparo.
Mr. Gasparo.
Mr. Hanley.
Mr. Hanley.
Madame Rochefort.
Madame Rochefort.
Mr. Casey.
Mr. Casey.
Madame Bendayan.
Madame Bendayan.
Mr. Baptiste.
Mr. Baptiste.
Mr. Klassen.
Mr. Klassen.
Madame Lavac.
Madame Lavac.
Monsieur Ramsey.
Monsieur Ramsey.
Miss Church.
Miss Church.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. Morrissey.
Mr. Morrissey.
Monsieur Shifke.
Monsieur Shifke.
Mr. Sheehan.
Mr. Sheehan.
Miss Cedar Brampton South.
Miss Cedar Brampton South.
Miss Vandenbeld.
Miss Vandenbeld.
Mrs. Zaid.
Mrs. Zaid.
Miss Yip.
Miss Yip.
Mr. Baker.
Mr. Baker.
Monsieur d'Entremont.
Monsieur d'Entremont.
Madame Lalonde.
Madame Lalonde.
Mr. Pulowski.
Mr. Pulowski.
Monsieur Zuberi.
Monsieur Zuberi.
Mr. Eolfson.
Mr. Eolfson.
Madame Lapointe, Rivière-des-Mille-Îles.
Madame Lapointe, Rivière-des-Mille-Îles.
Mr. Baines.
Mr. Baines.
Mr. Cotto.
Mr. Cotto.
Mr. Gahir.
Mr. Gahir.
Miss Hefner.
Miss Hefner.
Madame Lapointe, Sudbury.
Madame Lapointe, Sudbury.
Mr. Sousa.
Mr. Sousa.
Mr. Carr.
Mr. Carr.
Miss Akan.
Mr. Khan.
Mr. Al Saoud.
Mr. Al Saoud.
Madame Auguste.
Madame Auguste.
Mr. Chang.
Mr. Chang.
Mr. Clark.
Mr. Clark.
Mr. Connors.
Mr. Connors.
Madame Dandurand.
Madame Dandurand.
Mr. Danko.
Mr. Danko.
Monsieur Deschênes-Thériault.
Mr. Deschênes-Thériault.
Mr. Earl.
Mr. Earl.
Miss Fancy.
Miss Fancy.
Mr. Fanjoy.
Mr. Fanjoy.
Miss Harrison.
Miss Harrison.
Miss Hurdle.
Miss Hurdle.
Monsieur Joseph.
Monsieur Joseph.
Oh, what the hell?
Mr. McDonald Kerrigan.
Mr. McDonald Cardigan.
Mr. Mallette Bay of Quinty.
Mr. Mallette Bay of Quinty.
Miss Miedema.
Miss Miedema.
Madame Mingarelli.
Madame Mingarelli.
Miss Naughton.
Miss Nathan.
Miss Wien.
Miss Wien.
Monsieur Tumba.
Mr. Tumba.
Miss O'Rourke.
Miss O'Rourke.
Mr. Rana.
Mr. Rana.
Mr. Saini.
Mr. Saini.
Monsieur Sari.
Monsieur Sari.
Mr. Sawatsky.
Mr. Sawatsky.
Miss Sodi.
Miss Sodi.
Monsieur Saint-Pierre.
Mr. St. Pierre.
Miss Tessa Dirksen.
Miss Tessa Dirksen.
Monsieur Villeneuve.
Monsieur Villeneuve.
Monsieur Watchhorn.
Monsieur Watchhorn.
Monsieur Perron.
Monsieur Perron.
Monsieur Deschênes.
Monsieur Deschênes.
Monsieur Bonin.
Monsieur Bonin.
Monsieur Sainte-Marie.
Nobody wants a pipeline.
Madame Larouche. Madame Godreau.
Madame Godreau.
Monsieur Beaulieu.
Monsieur Beaulieu.
Monsieur Barcelou-Duval.
Monsieur Barcelou-Duval.
Monsieur Blanchet-Jonca.
Monsieur Blanchet-Jonca.
Monsieur Lemire.
Monsieur Lemire.
Mr. Davies, Vancouver Kingsway.
Mr. Davies, Vancouver Kingsway.
Monsieur Boulris.
Monsieur Boulris.
Mr. Johns.
Mr. Johns.
La Chambre attend.
The House will now wait for the electronic voting period to end before resuming its proceedings.
Yeah, that's exactly how we thought the vote was going to go. It was going to go Libs no, NDP no, Bloc no, and Conservatives the only one. They're the only ones who want the pipeline. Now, there are times in politics where it's regardless of whether or not the actual bill is good or the motion is good. They just vote based on partisan interest. And it's yet to be revealed whether or not this is one of those cases. I mean, we still have 2 years where, let's just say there was a private proponent to come forward tomorrow. Like, let's just say Enbridge was like, oh, we'll take up that pipeline, we'll fund it. And Danielle Smith then did the consultation and got Indigenous rights approval, and somehow David Eby was on board. Let's just say all those things got magically done overnight. It still has to go to Carney's national project building or national interest building office or whatever it is, and then it takes 2 years to approve from then. So all it was supposed to do was to take the process down from 5 to 2 years, but Danielle Smith would still then have to go and do all those processes in itself, and there still has to be a private proponent, which there isn't right now. So, yeah, I mean, the motion is basically just to kind of get it going faster than 2 years. I'm not really sure what the motion would achieve to begin with, but the idea is that, are you actually going to live up to your MOU? And Liberals would obviously vote against that. It's even if let's just say they voted with it, I'm not really sure how much difference it would make to the overall process that's in place in the first place already, because there still is no private proponent. I personally think Danielle Smith should just, I'm not sure what she needs to do. Maybe she needs to give a better deal to Enbridge or something like that. There's still the federal policies in place, but I think she needs to just like override some of, like, just get the pipeline going. Go and tell Carney, listen, we got the people in place, we've got Indigenous rights in place, we've got everything in place, you just need to approve it. And it should be done within like 6 months. It shouldn't take 3, 4, 5 years. And Carney's like, oh no, it'll take 2 years now. We've got this National Building Projects Office and all this bullshit. It's really not a difficult matter. Pipelines to begin with take 5, 10, 15 years even to build. So let's just say even if everything was in place today, and even if Carney approved it within 2 years, it still won't even get fully built for another 5 to 10 years. Like, a pipeline doesn't just magically appear overnight. They do take a long time to build.
The House that the electronic voting period has ended.
Des députés n'ont pas pu voter en raison.
If members were unable to vote due to technical difficulties, they may now use the raise hand function and the chair will recognize them.
Vois pas de main levée.
I see no hands raised. The table will now compile the results of the vote.
139, 139. Les contre, 196, 196.
Je déclare l'amendement.
I declare the amendment defeated.
The next question is on the main motion. The question is as follows. Mr. Upal, seconded by Mr. Halan, moved that the House, A, take note of the memorandum of understanding between... Dispense? No, I didn't think so. Take note of the memorandum of understanding between Canada and Alberta of November 27, 2025, and B, support the construction of one or more pipelines enabling the export of at least 1 million barrels a day of low-emission Alberta bitumen from a strategic deepwater port on the British Columbia coast to reach Asian markets, including through an appropriate adjustment to the Oil Tanker Moratorium Act, while respecting the duty to consult Indigenous peoples. If a member participates... Yeah, if
Are you going to tape that?
We're having a vote here. We're having a vote. If a member... Yes, the Chief Government Whip.
Thank you, Mr. Speaker. I believe if you seek it, you'll find consent to apply the results from the last vote to this one, with Liberal members voting nay.
Yeah, 100%.
That's
what I thought.
Chief Opposition Whip.
Conservatives agree to apply, but Conservatives will be voting in favor of this motion.
Le Whip.
The Bloc Québécois Whip, the honourable member for Berthier-Masquinongé. Yes, Mr. Speaker, the Bloc agrees to apply the vote and will be voting against.
For Vancouver Kingsway.
The New Democrats will apply the results of the last vote, again voting no.
And the honourable member for Saanich Gulf Islands.
Merci, Monsieur le Président. Thank you, Mr. Speaker. The Green Party agrees to apply and votes against.
The table will now compile the results of it.
Will now compile the results of the vote.
Yeas pour, 139, 139. Yeas contre, 196, 196.
I declare the motion defeated.
The next question is on the supplementary estimates B.
Just as we thought, that was defeated.
The question is as follows. Mr. Ali, seconded by...
Oh, so there's another vote too? They're doing two votes?
Ali, seconded by Mr. McKinnon Gatineau, moves that the supplementary estimates B for the fiscal year ending March 31st, 2026 be concurred in. If a member participating in person wishes that the motion be carried or carried on division, or if a member of a recognized party participating in person wishes to request a recorded division, I would invite them to rise and indicate it to the chair. The Chief Government Whip.
Carried on division, Mr. Speaker.
Is that agreed?
Carried on division, agreed? I therefore declare the motion carried on division. No? Okay. Mr. Ali, seconded by Mr. McKinnon Gatineau, moves that a bill entitled an act for granting to His Majesty certain sums of money for the federal public administration for the fiscal year ending March 31st, 2026 be now read a first time and be printed. The motion is deemed adopted. Monsieur Ali, appuie.
Mr. Ali, seconded by Mr. McKinnon Gatineau, moves that Bill C-17, an act for granting to His Majesty certain sums of money for the federal public administration for the fiscal year ending March 31st, 2026, be now read a second time and referred to a committee of the whole.
Si un député
if a member participating in person carried on division, agreed?
No, so I don't. Oui, c'est ça. Oui, j'ai la déclaré à distance. Là, maintenant.
Je quitte maintenant le fauteuil.
I will now leave the chair in order for the House to...
Wait. Okay.
I am now leaving the chair for the House to go into Committee of the Whole.
Okay. That's what we saw that we needed. Everyone's clapping because that's all we really wanted to tune into. I'm kind of reluctant to get back to the Justice Committee. I am going to keep it up in my back area here, just to kind of see if there's anything that we're gonna miss in the Justice Committee. But I'm gonna tune out at this point. I'm gonna go get some clips out on the channel from Question Period and from the committee we just watched and things like that. But I think I'm gonna tune out for today. That's it for me. We'll quickly hear this for a second.
We would like the bill to remain in its habitual form.
Mr. Speaker, the form of this bill is the same as the past in the previous supply period. Thank you, Mr. Speaker.
Shall Clause 2 carry on division? Shall Clause 3 carry on division? Shall Clause 4 carry on division? Shall Clause 5 carry on division? Shall Clause 6 carry on division? Shall Schedule 1 carry on division? Shall Schedule 2 carry on division? Shall Clause 1 short title carry on division? Shall the preamble carry on division? Shall the title carry on division? Shall the bill carry on division? Shall I rise and report the bill? Agreed.
Okay. I just wanted to see how they were going to proceed with that, because, I mean, it's usually the same thing. It's just on division, as the majority gets to decide how that's going to work. We don't need to stay here any longer. We've kind of done enough for today. Like I say, if there's anything that we're going to miss in the Justice Committee, I'm going to keep it up on my other monitor. I'm going to continue to watch it, and if there's anything that happens in the next few hours, I'll go and clip it and put it out on the channel. But I think most of the Justice Committee that had its like really spicy parts, we already caught at the beginning of the committee. So I will see you guys tomorrow, 2 p.m. Eastern Standard Time for Question Period, and then we've got committee in the afternoon at 4:30. So those will be the two streams that we have. Excuse me. Thank you very much, Wee Cookie, for the super chat. Thank you very much, Megan, for the super chat, and thank you, A True Canadian, for the gifted memberships. I really appreciate you guys, and I really appreciate you guys. Sorry, stumbling over myself here. Tuning in and watching, and I'll see you guys tomorrow. And yeah, still got a bit of work to do. I got to go put some clips out on the channel. So, cheers, guys. Thank you so much. See you tomorrow. Have a good evening. Bye bye.